Okay. So, wait, I'm sorry. This. All right. Good morning, everybody. It is September 22nd. And to start off today, we are going to start off with our EIB, regular EIB meeting, and then we will be going into the hearing. So with that, Ms. Jones or Mr. Lopez, would you do the roll call for our members this morning that are present?
I will. Thank you. Can you hear me?
Yes.
Member Bitzer, are you present? It is. Thank you.
Oh,
Yes.
hold on, Ms. Jones. Would this be on?
No, just transcribe the hearing. Thank you. Member Ely?
Present.
Member Garcia?
Here.
Member Honker?
Present.
Chair Sweeney?
Present.
Vice Chair Trujillo? Thank you. All present and accounted for.
Thank you, Ms. Jones. With that, we've been given a proposed agenda. And so if all the members can take a look at that, and we'll be looking for a motion to approve the proposed agenda.
I move that we approve the agenda for the meeting today, September 22nd.
Thank you, Member Garcia.
I'll second.
Thank you, Member Hunker, for your second. Is there any revisions or discussions with the motion on the floor? If not, Ms. Jones, would you please do a roll call vote on Member Garcia's motion?
Member Bitzer, how do you vote on the agenda? His mic is on. Member Bitzer, how about unmuting and giving us a vote?
Yeah, it said I couldn't unmute myself.
Okay.
I
We
vote
hear
yes.
you loud and clear. Thank you. Member Ely, how do you vote?
Yes.
Member Garcia?
Yes.
Member Honker?
Yes.
Chair Sweeney?
Yes.
Vice Chair Trujillo?
Yes.
The motion passes.
Thank you, Ms. Jones. With that, we will go on to agenda item number 3, which is the approval of the July 18th, 2025 meeting minutes. Those were emailed out by prior to this meeting. Does anybody have, well, one, I'd love to entertain a motion so we can get the discussion started.
I will move.
I'll move approval.
I'll yield to Member Bitzer. And I'll second.
I'll move approval of the July 18th minutes.
Thank you, Member Bitzer.
And I'll second.
Thank you, Member Honker. Is there any discussion of any revisions to the meeting minutes for July 18th, 2025? No? All right. With that, Ms. Jones, can you please do a roll call vote on Member Bitzer's motion to approve the July 18th, 2025 meeting minutes?
Member Bitzer, your vote?
I vote yes.
Thank you. Member Ely?
Yes.
Member Garcia?
Yes.
Member Honker?
Yes.
Chair Sweeney?
Yes.
Vice Chair Trujillo?
Yes.
Motion passes.
Thank you, Ms. Jones. With that, we will go to agenda item number 4, which is public comment. And Ms. Jones, do we have anybody either on the platform or signed up that we would like to make a public comment at this portion of our agenda?
No one has reached out to me to make public comment, Chair Sweeney.
Thank you, Ms. Jones. And I'm looking around here in person. I don't see anybody raising their hands. With that, We will go on to agenda item number 5. Agenda item number 5 is EIB 25-32R in the matter of proposed amendments to 7.6.2 NMAC Food Service and Food Processing, a request to change hearing date. And I think we have Ms. Napolitano on the platform and Mr. Knight on behalf of NMED. Turn
Yes.
it over to you.
All right, great. Hi. Good morning, members of the board. My name is Mia Napolitano. I am representing the New Mexico Environment Department in EIB 2532. And yes, with me is Andrew Knight as co-counsel. And then we also have Marcy Nevarez with the Environmental Health Bureau. So we're here to request a new hearing date. The original hearing date is set for October 23rd of 2025, and we would like to move that to April of next year during the EIB's regularly scheduled meeting. And the reason for this request is we would just like to have some more time to engage the public and stakeholders with these proposed changes.
Thank you, Ms. Napolitano. Sorry, having to turn around here, make sure nobody else has anything to say. Is that all for right now, Ms. Napolitano?
Yes.
Okay. Thank you so much. So I guess it turns it over to us here, fellow board members. Your thoughts about moving the hearing date for this item? Is there any discussion or questions?
No,
Yes.
I have no questions and I have no objection to moving the hearing date.
Thank you, Member Ely. Anybody else?
No.
All right.
I'm sorry, I may have missed something. Do we have a new hearing date or is this just to postpone?
Is there a specific date, Ms. Napolitano, or is there just a postponement to April?
Right, we were asking to schedule the hearing date to April during the EIB's regularly scheduled meeting. So I believe that's April 24th.
Yes, thank you for the clarification. Is that helpful, Member Hunker?
Yes.
April 24th. All right, I don't see anybody. I see a thumbs up from Member Bitzer and others. So with that, I think we just need to have a motion to move the hearing date to next year, as requested by NMED and supported by some of the other parties. Members? Yes.
I move that we move the hearing of EIB 25-32 to April 2026, and I suppose that would be April 24th, our next meeting date in April.
I'll second that.
Thank you, Member Garcia, for your motion, and Member Bitzer for your second. There's no other discussion. Ms. Jones, would you please do a roll call vote on Member Garcia's motion?
I will. Member Bitzer, how do you vote?
I vote yes.
Member Ely?
Yes?
Member Garcia?
Yes.
Member Honker?
Yes.
Chair Sweeney?
Yes.
Vice Chair Trujillo?
Yes.
The motion passes to move EIB 2532 to the April 2026 regular EIB meeting.
Thank you, Ms. Jones. All right, with that, we get to agenda item number 6, which is EIB 25-23R, public hearing in the matter of proposed adoption of 20.2.92 NMAC Clean Transportation Fuel Program. And at this point, I will turn it over to our Madam Hearing Officer, Ms. Orth.
Thank you, Madam Chair. Again, my name is Felicia Orth, hearing officer appointed to conduct a hearing in the matter of the proposed adoption of 20.2.92 of the New Mexico Administrative Code. This is the Clean Transportation Fuel Program, docketed by the administrator as EIB 25-23 R for rulemaking. The hearing will be conducted pursuant to the board's rulemaking rules in 20.1.1 of the New Mexico Administrative Code. A pre-hearing order I entered back in July, and other orders and decisions that have been made since the petition was filed. We have a lot of parties in this matter, and I will ask for appearances in just a little bit. I'd like to get through some other preliminary comments before I do that. And before I go any further with the preliminary comments, I'd like to invite, I'm sorry, with my preliminary comments, I'd like to invite Lisa O'Grady up for those who might want to switch to Spanish. Ms. O'Grady.
Good morning. Thank you very much. My name is Lisa O'Grady, and we're providing Spanish interpretation this morning. For anybody that is appearing on the WebEx platform, you can choose your Spanish channel. The globe is found at the bottom left-hand corner of your screen. You just click on the globe, and then you choose your language. You can also adjust the how much you hear the interpreter and how much you hear English by moving the bar accordingly. If there's anybody present in the hearing room that would like to hear the Spanish interpretation, please come and see me and I can give you some headphones. We're providing that service here as well. Buenos días, con mucho gusto, me llamo Lisa O'Grady y le voy a explicar cómo escoger su idioma para acceder a los canales de español. Entonces, en la esquina inferior a la izquierda van a ver el mundo. Allí le pueden hacer clic y luego escoger español. También puede ajustar la cantidad del inglés y el español que escuche, nada más deslizando la barrita y así puede ajustar el idioma.
Thank you, Ms. O'Grady. I believe I need to ask your interpreters to swear or affirm to faithfully interpret. Would you introduce them, please?
Yes, Madam Hearing Officer. I have Betty Zeman, federally court certified interpreter, and Amelia Cardeña, state court interpreter.
All right, thank you, Ms. Zeman and Ms. Cardeña. Do you and each of you swear or affirm that you will faithfully interpret between Spanish and English and Spanish? Thank you. Did Ms. Zeman also confirm?
I have not heard yet.
Yes, thank you very much. Thank you. All right, we have a big task ahead of us, all of us, and I imagine that might call for a little more grace than sometimes we need to get through us. Again, we have a lot of parties, and I wanted to share with you.
Oh, man.
Sorry, let me first ask if you have a laptop in the room, please mute it. Otherwise, the sound coming through there will interfere with what's happening in the room. And also, while I'm thinking about it, if you have a phone, please reach for it and mute it or set it on stun. All right. So a lot of parties, again, I'm going to ask for appearances in just a moment. I did want to say that we will be hearing technical evidence from a number of parties, and we'll be hearing from them in this order. This was agreed upon in a pre-hearing conference last week. We'll first hear from the petitioner, the New Mexico Environment Department, then from Infinium, then from Verde Clean Fuels, then GEVO, or Please correct my pronunciation if necessary. Next, renewable fuels and world energy. Then growth energy, national sorghum producers, Rio Valley biofuels, Coalition for Clean Affordable Energy, then HF Sinclair, then we may well hear a statement from Mr. Nicholas Maxwell or Mr. Bruce Weatherby, then NAMOGA and API, then Oxy USA, then American Fuel and Petrochemical Manufacturers. The order of cross-examination will change each time depending on which witness or panel of witnesses is being cross-examined, so I won't read that out. We do have some of our witnesses being presented as panels. What that means is that they will give their summary of their direct testimony, and then we'll hear from each of them, and then they'll be cross-examined collectively. We have provided for opening statements of 20 minutes apiece. The technical witnesses, all of whom pre-filed their testimony, which can be found in each notice of intent to present technical testimony, all of that can be found along with every pleading and other bit of material in this matter on the NMED Docketed Matters webpage. Go to Docketed Matters and scroll down to EIB 25-23. Cross-examination is limited to 30 minutes. The entirety of our hearing is being transcribed by David Lee, court reporter. Please reach out to Mr. Lee for a copy of the transcript. No decisions will be made this week or next or even in November. What we will do is have the transcript filed with the administrator. She will notify the parties as to when that transcript has been filed. The parties will then have an opportunity to submit post-hearing submittals. I'll have an opportunity to write a report, which ideally will assist the board as they step through their deliberations. And then the board's deliberations will be scheduled at a subsequent meeting, and all parties will be informed as to when those deliberations will occur. The board always, of course, reserves to itself the right to deliberate immediately following the close of the evidentiary record. I should mention that as well. In the complex rulemakings, it's not the usual thing. So we will be hearing an awful lot of technical testimony. We will also be inviting public comment. Public comment will be invited at 1 p.m. every day that we are in hearing. Then public comment will also be invited this evening, which is the first day of the direct cases, and on the evening of November 17th, which will be our first day of hearing the rebuttal cases. Please collect your thoughts before you indicate that you'd like to give public comment, because I can only accept it from you one time. You'll be limited to 3 minutes. And to the extent you have more to say than can be said in 3 minutes, we invite you to submit written public comment and submit that to the administrator, Pam Jones, who's over there, at any time before we adjourn. It becomes part of the record, gets put up on the web page, and the board can take it into account the same as everything else in the record. Let's see. We do have a couple of motions to handle. Let me ask for appearances first. So here for the Environment Department, Council.
Good morning, Madam Hearing Officer and members of the board. My name is Kelsey Sona with Robles, Rael, and Anaya, and I'm here representing the New Mexico Environment Department. And I will also ask my three co-counsel to introduce themselves.
Thank you.
Good morning, Madam Chair and members of the board. My name is Jessica Nixon. I'm also with Robles, Rael, and Anaya here on behalf of the department.
Good morning, Madam Hearing Officer, members of the board. My name is Dylan Vieskis. I'm an Assistant General Counsel for the Environment Department and appearing on behalf of NMED as well.
Hi, I'm Kelly Villanueva with NMED, Assistant General Counsel, also appearing on behalf of NMED. Thank you.
Thank you. Let's see. Is there anyone here for Infinium?
Good morning, Madam Hearing Officer and members of the board. My name is Graham Noyes. I'm a California attorney. I'm appearing with Ann Menard as New Mexico counsel and appearing on behalf of several companies that are low carbon fuel producers or developers as separate parties. Firstly, Infinium. Secondly, Verity Clean Fuels. And third, the SAF, Sustainable Aviation Fuel Producers, GEVO, NXT, and World Energy. Thank you.
Thank you very much. Growth Energy. Oh. All right. National Sorghum Producers. Actually, Mr. Duff reached out via email. I think he may join us later. Rio Valley Biofuels. Coalition for Clean Affordable Energy. I think that's Mr. DeSalen.
Good morning, Madam Hearing Officer and members of the board. My name is Charles DeSalen, and I'm representing Coalition for Clean Affordable Energy. And I have two co-counsel who are here with me today. One of them is right here to my right. Will introduce herself. And the other one is on the platform. Thank you.
Thank you.
You hear me? Here we go. Thanks. My name is Kara Lynch. I'm an attorney with Coalition for Clean Affordable Energy here with Charlie DeSalen, and we are co-counsel with Sarah Gerson online, who will introduce herself at this time as well.
Thank you. Ms. Gerson.
You're on mute, Ms. Gerson.
Pam will unmute you here.
Good morning. Sarah Gerson for Coalition for Clean Affordable Energy, and I am an attorney with Earth Justice.
Thank you very much. Pam, if you can, please give Ms. Gerson the ability to unmute herself. Let's see. HF Sinclair.
Can you hear me?
Yes.
Thank you. Good morning, Madam Hearing Officer, Madam Chair, and board members. My name is Stan Harris. I'm with the Modrell Sperling Law Firm, representing HF Sinclair. With me is my partner and co-counsel, Stuart Boutier. I also have with me from HF Sinclair, Ashley Rich and Stephen Emmon.
Thank you very much. Let's see. Is Mr. Maxwell on the platform?
Good morning, Your Honor, members of the board. Fellow parties and esteemed members of the public, my name is Nicholas Ray Maxwell. I'm one of the people of Lee County, New Mexico, and I am entering my appearance today in this matter. Thank you.
Thank you. Is Mr. Weatherby with us? He may join us later. NMOGA and API.
It's on? Okay. Good morning, Madam Hearing Officer, Madam Chair, and members of the board. My name is Dal Mullenberg. I'm with the law firm of Gallagher and Kennedy and appearing today on behalf of the New Mexico Oil and Gas Association. I have two co-counsel with me and I'll let them introduce themselves.
Good morning, Madam Hearing Officer, members of the board. My name is TJ Trujillo, and as Mr. Mullenberg indicated, I'm with Gallagher and Kennedy. Thank you.
Thank you.
Good morning, Serafina Saluja for NMOGA and API at Gallagher and Kennedy.
Sorry, ma'am, your name again?
Oh, yes, Serafina Saluja. Thank you.
Thank you very much. Oxy.
Good morning, hearing officer and Madam Chairwoman and members of the board. My name is Aaron Tucker of Holland and Hart, representing Oxy USA, and with me today, my co-counsel Leila Jones. Thank you.
Thank you. And let's see. What? Oh, please go ahead.
Thank you, Madam Hearing Officer. My name is Anne Menard, and I'm co-counsel with Graham Noyes for Infinium LLC, the SAF Producers Group, and Verde Clean Fuels.
Thank you very much. And last but not least, American Fuel and Petrochemical Manufacturers.
Good morning, Madam Hearing Officer, Madam Chair, members of the board. Jeff Wexler from Spencer Payne on behalf of American Fuel Petrochemical Manufacturers. I'll just mention as the hearing unfolds as well, you may see some of my other partners, Carrie Olson and Sharon Shaheen. Thank you. Good to see everyone.
Thank you. All righty. Let me ask, now that you've all introduced yourselves, if there's anyone who has a preliminary matter other than those four motions in limine that were filed by the department. Anyone identifying a preliminary matter other than that? Okay, I don't see any hands. So let's turn to those four motions. I studied the motions and the responses. I think this morning, instead of having argument from everybody, I really would just like to hear a brief reply from the department. So let's see, Ms. Sona.
Good morning. Can you guys see me with the computer here? Okay, I am short. Thank you, Madam Hearing Officer and members of the board. As I stated in the introduction, my name is Kelsey Sona, and on behalf of the department, I will provide you just a brief, less than 12-minute reply to address the four motions that we've filed. The department's four motions raise 6 matters for the hearing officer's consideration. American Petroleum Institute and the New Mexico Oil and Gas Association's consolidated response aims to point fingers instead of directly engaging with the department's granular evidentiary and practical concerns. It reads more like a motion than a response. I'd ask the hearing officer to disregard the points that are nothing more than a smokescreen to distract from the real issues to get us going in this hearing. The department is utilizing the permissible written motions practice opportunity for motions in limine to preemptively and expeditiously raise its concerns. First, the department seeks to strike the American Petroleum Institute and the New Mexico Oil and Gas's statement of reasons. It is improper under the procedural rules and the pre-hearing order because it is not a proposed final order, but rather a response to the department's petition. Everything in the statement is responsive to the petition, which is not the matter before this board in the next 2 weeks. Its relevance would have been served if API and NMOGA had submitted it during the initial meeting when the petition was considered. Instead, they defend the substance of their approach, but not the procedural timing and format problem. At this point, even the substance of the statement of reasons does not aid the board in its decision-making role, as it lacks explanatory rationale and fails to identify specific reasons for the proposed modifications. The board should not be asked to consider irrelevant information. Thus, the department is asking the hearing officer to strike the statement of reasons for failing to comply with the board's procedural rules. Additionally, the department is seeking to exclude the American Petroleum Institute and the New Mexico Oil and Gas Association's joint statement, the reasoning within their red line, Mr. Schubert's testimony, the Stillwater report, and Mr. Rensing's testimony. These filings were made pursuant to the notice of intent to present technical testimony, not through public comment. A party's presentation of their perspective must be carefully considered because the hearing must be fair and equitable to all and balanced with the effective presentation of evidence and points of view. This is not an adjudicatory proceeding. We recognize that. However, it is adversarial in the sense that there are differing and competing viewpoints that will be presented to this board. Recognizing this, the board's rules provide for opportunities to test a witness's viewpoint and their credibility and their qualifications, along with the exhibits they're presenting. Notably, I want to be clear, the department does not challenge that Ms. Felix, Mr. Searles, Mr. Schubert, and Mr. Rensing are educated and experienced individuals. Instead, what the department is challenging is that the qualifications to present the specific testimony offered are not met here. Based on the testimony filed, which cannot be expanded or changed during oral presentation, the department has evaluated the credibility of these witnesses and the Stillwater report. The department is asking the hearing officer to reasonably apply the procedural rules to ensure fundamental fairness and get us through this hearing in a timely manner. For the joint statement, the department seeks relief due to its procedural rule violations, the witness's lack of personal knowledge, and substance constituting technical testimony without the necessary qualifications. Evidence deemed incompetent is not admissible in these proceedings. The Merriam-Webster definition of incompetent highlights that it means lacking the qualifications needed for effective action, not legally qualified, and inadequate to or unsuitable for a particular purpose. The joint statement is based on information passed along by organization members and unnamed experts, which is not information within the personal knowledge of the witnesses, and therefore constitutes incompetent evidence. In that same vein, this joint statement constitutes technical testimony, requiring specific qualifications and expertise that the witnesses lack. The testimony involves complex regulatory and technical issues, such as scientific modeling, assumption selection, economic impacts, and operational intricacies. The witnesses, Ms. Felix and Mr. Searles, lack the necessary qualifications to provide such testimony, as their expertise is in regulatory affairs and policy management. In a recent meeting with the department, Ms. Felix and Mr. Searles were unable to discuss the intricacies of their supposed solutions to the concerns they have about the rule. Another meeting with experts had to be called to progress the conversation. If anything, these witnesses may only be qualified to discuss the testimony on pages 8 through 10 if they can attest under oath that they were present for the meetings that they supposedly discuss. Additionally, the American Petroleum Institute and New Mexico Oil and Gas Association may file the joint statement as a comment letter without accompanying oral testimony. If these witnesses are allowed to testify, there needs to be protections to make sure they don't coordinate their stories or shape their answers to match each other. Otherwise, sorting out the truth and assessing their credibility will be far more difficult and take more time. Next, the reasoning within the American Petroleum Institute and New Mexico Oil and Gas Association's red line is technical testimony that under the procedural rules must be presented with a witness under oath, allowing for cross-examination to ensure the credibility and reliability of the evidence. API and NMOGA only generally respond to this approach, saying it's common and that different witnesses will cover different topics. They do not address the specific issue of overlapping expert testimony and its procedural prejudice. As established, Ms. Felix and Mr. Searles are not qualified to discuss this red line. Moreover, certain topics raised in the red line are entirely absent from the remaining witnesses' testimony. These topics include a major red line change for fuel supply equipment credits. They include enforcement. They include discussion about the advisory committee's position on phased implementation stages, as well as other matters. It is fundamentally unfair to require this board and the parties to guess at which witness might have relevant knowledge. Forcing such guesswork also blocks inquiry into numerous issues outside of the scope of the witness's knowledge. It is plainly unfair and presents an inability for a fair and meaningful examination of the evidence, which is the purpose of us appearing all in person for a hearing. API and NMOGA argue that this reasoning is permissible in rebuttal, which is where it belongs. Next, Mr. Schubert is not qualified to offer economic opinions as he lacks a degree in economics and his professional experience does not include formal economic modeling. Instead, Mr. Schubert's professional experience is focused on corporate strategy and market development from a corporate perspective. He has no experience to support his opinions about the economics of the program from a regulatory perspective. His testimony is unreliable and irrelevant as it is based on Stillwater Report's flawed analysis. Mr. Schubert's inability to apply the statutory requirements in his analysis, despite knowing what it is, raises questions about his credibility and the relevance of his testimony. Section 74-1-18C2 of the statute sets the baseline year for our consideration in this hearing as 2018. His testimony that it should be a different year is irrelevant and incompetent, as the legislature has already spoken on this issue. All of the potential substitute witnesses for Mr. Schubert similarly lack necessary economic experience and expertise in the academic field. Next, the Stillwater Report misleadingly presents findings as economic modeling outputs, when its purported conclusions are instead only based on unreliable arithmetic calculations without applying all assumptions that they claim. The Stillwater report does not look at any benefits of this program. It only looks at costs. Even those cost analyses are unreliable, as they're based on cursory comparisons that New Mexico in 2030 will be analogous to California, and then applying simple arithmetic for projections. If admitted, the report must be given the weight appropriate. It is merely the viewpoints of oil and gas industry biased toward desirable business outcomes and not in any way connected with economic analysis as proposed by the department. Lastly, the American Petroleum Institute and New Mexico Oil and Gas Associations failed to respond to the specific problematic opinions identified by the department and instead just recited Mr. Rensing's qualifications already contained in his resume. This does nothing to help us understand why NMOGA and API believe that Mr. Rensing is qualified to talk about economic impacts of the program. Mr. Rensing only holds degrees in physics and astrophysics, not economics. In fact, his opinions are based on the department's report released on January 31, 2025. Nothing in the record but counsel's assertion denies that Mr. Rensing's opinions are based on outdated information. For these reasons, his testimony is not relevant and must be excluded. In conclusion, I offer this. Rather than permissibly filing written public comment or offering a 3-minute oral statement, which in historical practice categorically does not include cross-examination for credibility and qualifications, the American Petroleum Institute and the New Mexico Oil and Gas Association chose to move forward with filing testimony offered by witnesses. Nothing limits them from submitting their views through a less prejudicial manner in a standardized manner that is also allowed under these rules that is not an NOI. However, if they choose to proceed with their presentation as filed, and if such is permitted by the hearing officer, procedural protections are necessary. Whether this is by excluding certain evidence and testimony or through specific instructions to guide us through their examination, it is necessary to have protections to ensure that this hearing is completed timely and all relevant evidence and views are heard. Thank you very much for your consideration.
Thank you, Ms. Zona. So again, I studied the motions, the responses from NMOGA and API and from Mr. Maxwell, and I appreciate it. Mr. Molenberg, I see you on your feet. I don't actually want to hear more argument.
And thank you, Madam Hearing Officer. In fact, I'll leave it to you, and I don't really intend to make more argument. I just want to make an objection to the reply, because essentially it was a re-argument of the original motions, not just a reply.
All right.
And I know you allowed an opportunity for a brief reply, but I think Ms. Sona went way beyond that.
All right. Your objection is noted. Thank you.
Your Honor, this is Mr. Maxwell. I share the objection.
Thank you, Mr. Maxwell. So as to the SOR, excuse me, I say SOR, Statement of Reasons, and the red line, I wouldn't strike those. I would only note that, in fact, because we have not yet made an evidentiary record, those exhibits, you could say, are premature, if you will, insofar as the red line exhibit is really very close in format to what I'm going to be asking from all parties who would like to offer a post-hearing submittal. to set it out like that. And then for my report, I will compile everyone's suggestions section by section. Right now, again, NMOGA and API don't have the transcript citations, the witness testimony citations or exhibit citations. All of that's going to come after we make the record. That's what I am going to be looking for. So they're premature, and I wouldn't advise anyone to, among the board members, excuse me, to rely on them just yet because they're premature, but I don't believe they are harmful. The joint statement from Ms. Felix and Mr. Searles, we've had testimony like this before in rulemaking where, for example, the executive director of an organization makes a general comment without necessarily having the technical background that would be necessary, if you would, to offer actual expert testimony. I am not inclined to strike that either. And Ms. Sona, I would encourage the department to, I think voir dire is going to be important for Ms. Felix, Mr. Seals, Dr. Schubert, and Dr. Rensing. And I will invite everyone, if you are aware, by virtue of having read the resume, that someone has a PhD, if you would please use the honorific. So I think based on the department's observations around the qualifications of those 4 witnesses in particular, and then I think there were 3 possible witnesses, that one protection, if you will, a procedural protection, would be in fact inviting voir dire for each of them in particular. And I did note the differences between the economic model submitted by the department and the Stillwater report. These are different types of submittals, but I'm again not inclined to exclude it, merely to invite you to do a rigorous cross-examination of those who will be discussing it. The 2018 observation, I think I would like Dr. Schubert to minimize whatever testimony he would be giving about that. This board was asked, instructed, mandated by the New Mexico legislature to use 2018 as a baseline. And I'm sorry, to use 2018 as a baseline, and observations that some other year might have been better or worse or more helpful is not helpful to this board. They're going to be advised, I'm certain, by their counsel to base their decision using 2018 as a baseline. So I'm not sure why observations about that are helpful. I think they're irrelevant. All right, so having said that, the 4 motions are denied, along with the invitation to the department to do voir dire, rigorous cross, and a request of NMOGA to ask Dr. Schubert not to focus his testimony around using 2018 as a baseline. All right. Any other preliminary matters? I see no hands. Ms. Sona, I believe Ms. Miano is your first witness. Director Miano, excuse me. And, oh, Mr. Mullenberg. Oh, yes, I'm sorry. That's correct. I forgot to ask for opening statements. I knew there was something. I knew there was something. Also, I have been asked to remind everybody to read slowly. If you're reading something, it's definitely a usual human impulse to kind of read more quickly or speak more quickly. So please, if you're reading from something, read slowly. Ms. Sona, would you like to offer your opening statement now? Just as a reminder, 20 minutes, and I'm using my phone to as a stopwatch.
If I may, Madam Hearing Officer, I'm going to grab my phone so I can make sure I stay on track.
And I'm happy to hold up my hand for 5 minutes.
Thank you. I did time this, but you asked me to provide it a little slower, so. Good morning. We are here. Madam Hearing Officer, Chair Sweeney, Vice Chair Trujillo, and members of the board. My name is Kelsey Sona. I'm here representing the New Mexico Environment Department, along with my colleagues. We are here to assist an incredible group of department staff and experts to put forward explanations and support for this board to adopt the Clean Transportation Fuel Program regulation at 20.2.92 in the New Mexico Administrative Code. This hearing is an important step in implementing a visionary strategy for New Mexico's future and maintaining our commitment to safeguarding health, welfare, and environment in New Mexico, while also providing significant economic opportunity and infrastructure investment. The New Mexico legislature, representing the voice of the people, has already set ambitious goals to achieve reductions in carbon intensity by 2030 and 2040, with the benefit of reducing greenhouse gas emissions. We know from other low carbon fuel jurisdictions that this approach works. Decarbonization actually occurs, jobs are added, and economic investments are made. The rule promulgation mandate from the legislature speaks to the urgency of implementing this policy. Just 17 months ago, the legislature considered the technical complexity of the issues, the broad stakeholder issues that must be considered, and the time-intensive nature of rulemakings. And yet it still mandated that July 1, 2026 be the adoption date and implementation date for the CTFP. The department and its Climate Change Bureau rose to that challenge. They've developed an incredible rule. The rule integrates all of the statutorily mandated requirements and aligns with the legislature's goals. Specifically, it achieves the following. Establishes a standard that gradually lowers the carbon pollution from transportation each year. Ensure carbon pollution from fuel is reduced by at least 20% below 2018 values by 2030, and at least 30% below 2018 levels by 2040. Regulate in a technology-neutral manner. Provide for credit generation, market management, and cost controls while ensuring compliance is real, encouraging investment, and keeping consumer costs down. Allow utilities to participate, but require reinvestment of credit revenue into the community for transportation decarbonization. Account for and coordinate with other similar low-carbon fuel programs, including the federal transportation fuel regulations. Not discriminate against fuel just because it came from outside New Mexico. require periodic review of the rule, including by the advisory committee, contain deferral protections for addressing emergency or certain forecasted considerations, and lastly, set up fees to cover the costs of running and enforcing the program. You will hear testimony from Michelle Miano this morning to describe what a clean transportation fuel program is and does, followed by testimony from numerous department witnesses about the ins and outs of the technical aspects of the rule. The regulatory focus of the program is on the commercial activities for producing, importing, and distributing transportation fuel in New Mexico. Daily consumer activities, such as driving a car, purchasing a car, or fueling a car, are not subject to this rule. The program's market-based mechanism incentivizes the use of cleaner, low-carbon transportation fuel, thus reducing greenhouse gas emissions and providing new opportunities. This mechanism is technically sound and economically reasonable. Throughout the hearing, you will hear the term conservative when used by department's experts to discuss assumptions in their analyses. Conservative means low benefit and high cost assumptions to retain analytical credibility, particularly in areas where it may be subject to uncertainty. Notably, the program's benefits outweigh its costs by more than 2 to 1. The program is projected to deliver $1.7 billion, billion with a B, in cumulative net benefits through 2040. The economic development opportunities include the program's ability to stimulate the economy, create jobs, attract energy investment and infrastructure. The program will diversify the economy in New Mexico, such as with additional revenue streams and infrastructure development, and reduce revenue volatility for transportation fuel. Using the department's conservative approach, even with 100% pass-through of cost to consumers, any potential fluctuation in gas prices that could be attributed to this program is projected to be less than the normal fluctuation you see on a weekly basis at the pump. While the rule impacts include driving innovation across the transportation industry, economics are not the only consideration this legislature has asked you to weigh. The program is also expected to avoid 10.5 million metric tons of CO2 equivalent through 2035, along with additional measurable benefits in reductions of air pollutants like PM 2.5, VOCs, and NOx. The rule will help the health and quality of life of New Mexicans by reducing the environmental degradation resulting from our use of certain transportation fuel. The department estimates the monetized benefits of this to be over $51 million in health benefits. The department staff tasked with implementing the program are going to be here themselves to tell this board why the department is ready to implement this rule. Their preparedness is evidenced by the strong agency collaboration they have had with other jurisdictions that implement similar programs, and is supported by expert consultants that are experienced in climate, economics, energy, and transportation matters in the regulatory field. Phased implementation is not necessary because New Mexico is going to be able to leverage the increased fuel diversity that was not present when the other jurisdictions were starting up their programs. With the authorities and compliance safeguards in the department's rule, the department is well positioned to manage risks and adapt as the program evolves. The department's witnesses, drawing on their deep expertise, will demonstrate how this rule, as well as its benefits and cost analyses, are grounded in science and economics. Importantly, the department's witnesses will explain what the statutory mandate to remain technology neutral actually means, and the New Mexico-specific considerations that went into the rule language to maintain neutrality while meeting the other statutory directives. You will hear testimony from the department about its decisions for parameterizing the GREET model, G-R-E-E-T, to ensure carbon intensity calculations reflect New Mexico's specific transportation fuel mix. You will hear from numerous department witnesses that this customized approach is the ideal approach used by all other low-carbon fuel programs, including the federal government. Our witnesses will reveal the facts around the unworkable ask to use so-called defaults in an unmodified version of GREET. You will hear how the department evaluated the many academic and scientific perspectives on how to approach the carbon intensity challenges for indirect land use change, a statutorily mandated consideration, and why the department decided to use the extensive expert panel reviewed values generated by the California Air Resources Board in 2015. The board must be attentive to national interests attempting to exploit New Mexico as a testing ground to steer change in the policies and laws that exist in other states. For example, the department's testimony will explain the policy objectives achieved by including book and claim provisions and reasons why its approach to avoided emissions is the best representation of reality. Although the environmentalists oppose these provisions, they exist in other programs and will ensure consistency among other programs per New Mexico's statutory directive. The department's testimony will explain the importance of certain aspects of the program. For example, the role of energy efficiency ratios accounting for energy efficiency of different powertrains in the wheel portion of the life cycle analysis. Efforts to controvert this program component only seek to lighten the compliance obligation without actually making fuels cleaner. Through its witnesses, the department will establish the rule contains robust safeguards and flexibility for market management, including the necessary tools to use in absence of formal rulemaking. In their testimony, the department's witnesses will address how the process for fuel pathways and carbon intensity calculations will stay current with science and modeling. For example, the rule requires the department to review all lookup, temporary, and ILUC for indirect land use change, carbon intensities, at least every 3 years, and come back to this board if updates are necessary. They annually recalculate electric distribution utility service area carbon intensities. They will also update the GREET-based pathway calculators to reflect significant scientific and modeling advances. Similarly, alternative fuel pathway validity is capped at 5 years unless superseded by new science or regulation. The department's witnesses will provide details on how the rule operates for consumer protection. Numerous provisions address this, including the inclusion of fuel supply equipment credit opportunities, public reporting and transparency, credit banking and trading, the credit clearance market, periodic rule review, a self-sustaining fee structure, reinvestment of certain revenues for low-income and underserved communities, and anti-manipulation provisions. Some of these requirements also help provide certainty and fairness to the process, as do provisions such as document creation, record keeping and reporting requirements, third-party verification, technology neutrality, and the New Mexico-specific scientific modeling approaches and updates. The witnesses will explain how these types of rule requirements will help minimize volatility and ensure a more predictable and controlled market so that costs are not being passed on to consumers. The witnesses will also explain how the regulated parties are assured of accuracy, program integrity, compliance flexibility, and known adaptability measures. The board must be vigilant to the fact that many of the demands rejected by the department for this first round of rulemaking come from profit-driven special interest groups. For example, oil, gas, and petroleum interests state that infrastructure is needed, but their red line removes from the rule fuel supply equipment credits, which are the exact credits intended to serve as economic incentive specifically tied to infrastructure projects, making them financially viable even in less immediately profitable and underserved markets. Upon careful consideration, the department said no to this change, which would take away from New Mexico a quantifiable and conservative economic and jobs benefit of $162 million. The program's design is rooted in extensive documented engagement with the public, technical stakeholders, industry, environmental organizations, New Mexico agencies, academia, and the other jurisdictions that have been here. It incorporates specific technical and practical adjustments throughout the process. Much of this started with the duly formed advisory committee that met 4 times and provided a lengthy report. Given all of the disparate interests represented on that committee, their approach was not to reach consensus, but to offer the department salient recommendations for the rule. Many of their proposals directly influence the language, the program features, and its limitations. In a critical step for additional input, the department released a comprehensive draft of the rule. Afterwards, the rule again underwent even more changes based on these comments that it received during that public comment period before the department petitioned this board for a hearing. Stakeholder engagement has continued and more modifications have been made, as you would see in the department's red line filed with its testimony. These include moving up the project credit date, correcting the baseline year in carbon intensity modeling, and other minor modifications. The department has continued to meet with stakeholders up through this morning. It is important for the board to know that this is a different kind of rule than what you usually consider. This sets up a clean fuel market. It is not a static command and control scheme. As program needs mature, the market develops, and conditions change, the department will return to the board for another rulemaking. Some of the parties' proposed red lines dramatically shift the policy goals of this program. While the department is not fundamentally opposed to these ideas, these approaches are not viable for the first stage of the program and are better suited for consideration in later rulemakings. Thus, this is not a static rule in the way the board usually sees, which is why overarching periodic review is a core component of the rule, and the department will demonstrate this commitment to this legislative directive. The department expects the testimony and questions over the next 2 weeks of this hearing may necessitate more small changes to the rule language for consideration during the rebuttal week of the hearing. In fact, the department is already having those conversations to address clarifying aspects of the rule, such as project credits, enforcement, certain carbon intensity calculations, and other matters. While some changes being discussed with interested parties may be addressed during the hearing, Some sought after changes are matters the department believes should be addressed in a future rulemaking. In conclusion, this proposed rule does a lot for economic, health, and environmental benefits, but it cannot do everything. It will not solve the global climate crisis, nor will it cure respiratory disease. The department's rule is a balanced approach designed to meet this state's unique needs and objectives. It is the result of substantial engagement with transportation fuel producers, fuel distributors, other individuals and entities in the transportation fuel market, environmentalists, community advocates, and other jurisdictions with similar programs. The rule doesn't bow to the requests that would hamper an emerging market. Let me leave you with this comparison to frame the testimony you will hear. The environmentalists are proposing a framework suitable for a mature market that has an established infrastructure. The American Petroleum Institute and deficit generating industry ask this board to adopt a market that has its legs cut out from under it, such that it's not going to get off the ground. All of the smaller proposals are from parties asking for a greater slice of the pie through more credits or less deficits. Cutting through all of this is the department's thought out and balanced plan for an emerging market with appropriate guardrails and protections to adapt. The department has submitted to you a plan that will guide transportation to cleaner fuel. This rule empowers choice. Embrace cleaner fuel or face the cost of pollution. New Mexico is moving fast and sitting on the cutting edge of climate science. The proposed regulation isn't merely a regulatory change. It's necessary to bring us a step forward for a better future for New Mexico. Together, we can pave the way for a sustainable and prosperous New Mexico with cleaner transportation fuel. Thank you.
Thank you, Ms. Sona. It is 10:15. I'm wondering if this is a good time for a break, and if the rest of you would consider whether you would like to offer your opening statement this morning or wait until you are about to put on your evidence later in the hearing. In the meantime, let's break till 10:30. Thank you.
From the break, please.
I don't have a hammer.
I know.
A gavel.
First chair's still in the line.
Oh, is she?
Yeah.
Ooh,
in the
okay.
bathroom. Just FYI.
Drat. You think she's okay with me starting?
Yeah.
Yeah? Okay.
Do you want me to go double check with her? I'll go check.
Okay. We are trying to get access to another bathroom, by the way. Okay, thank you. Actually, are you okay? While I'm
I just checked out the bathrooms over Tony and Naya, and we can use them. Just turn to the left side of that building, past the elevators. There's two more.
Thank you. Ms. Borchert has just reported. Before I invite the next opening statement, let me acknowledge that I neglected to call on 4 parties who entered an appearance, and I had confused myself because they're not among the list that I had made up for those making technical presentations, but they did enter an appearance. So I'm sorry if you were waiting for some invitation to put your appearance on the record. Let me start with RNG Coalition, Mr. Wade, or Mr. Surayas.
Good morning, Madam Hearing Officer, members of the board. My name is Yanni Psareas. I'm the State Legislative Affairs Manager for the Coalition for Renewable Natural Gas.
Thank you very much. And then Food and Water Watch, Mr. Lodell or Ms. Reno. No. Southwest Airlines, Lauren Tremblay. No. Or Low Carbon Fuels Coalition, Robin Vercruza. Oh, hello. Please come to a mic.
So, good afternoon or good morning, still morning, Madam Chair, and the board. I am Robin Vercruz with the Low Carbon Fuels Coalition, and look forward to the proceedings.
Thank you very much. Okay, so now let's return to opening statements. Mr. Noyes, would you like to offer an opening statement now or reserve? Thank you. Then let's go to, let's see, has Mr. Nasco joined us for Growth Energy? Nope. Has Mr. Duff joined us for National Sorghum? No. Has Mr. Smith joined us for Rio Valley Biofuels? No. Mr. DeSalen noted that he will be reserving. Let's see, Mr. Harris or Mr. Boutier for HF Sinclair? Thank you. Let's see, Mr. Maxwell or Mr. Weatherby, would you like to offer a statement now or later?
Your Honor, this is Mr. Maxwell. I would reserve my statement for later.
Thank you. Then let me ask. Yes.
Bruce Weatherby here. I'll also reserve for a time later.
Thank you very much. Mr. Surayas, would you like to reserve for now or later?
We'll be reserving our testimony. Thank you.
All right, thank you. And Ms. Vercruz, any statement to make at this time? All right, thank you. Then to, let's see, Namoga, and I understand, Mr. Molenberg, you would like to offer an opening now.
Thank you, Madam Hearing Officer. Madam Chair, members of the board, thank you for the opportunity to appear before you today and in this proceeding. Again, I'm here on behalf of the New Mexico Oil and Gas Association and the American Petroleum Institute. My name's Dal Mullenberg. I want to begin by recognizing the enormous responsibility you bear in this process. The legislature has handed you a difficult but important assignment to establish a clean transportation fuel program that advances New Mexico's climate goals while protecting consumers, ensuring fuel reliability, and respecting the state's statutory commitment to technology neutrality. This is not an ordinary rulemaking. You are not simply setting compliance obligations as you would in a traditional environmental regulation proceeding. What you are being asked to promulgate is a rule where many of the desired changes will be determined in a marketplace in which credits and deficits will be traded, in which suppliers will make investment decisions, and in which consumer behavior is expected to change. That is a heavy lift. Other states have gone down this path, California, Oregon, and Washington, and they can attest to both the opportunities and the pitfalls. Those programs have shown that if designed well, A clean fuel standard can create incentives that spur innovation, but they also reveal the risks: potential supply disruptions, higher consumer prices, and intended or unintended favoritism towards certain technologies. Our clients, Nemoga and API, represent the company that supply the majority of New Mexico's transportation fuels. These companies have been operating under similar programs elsewhere and bring hard-earned experience about what works, what does not, and how unintended consequences can ripple through a state's fuel system. We fully respect the board's charge. We do not appear here to oppose the idea of a clean transportation fuel program. The legislature's already spoke on that point. Rather, we're here to provide alternatives intended to ensure that the program can be implemented and function properly, as well as to mitigate potential cost impacts to consumers in New Mexico. We do this by sharing lessons learned, identifying risks, and proposing modifications that will help the board with its difficult task. I would like you to keep in mind a simple procedure. If this program is to work, it must be fair, science-based, and predictable. It must treat all technologies equally, allow the market to function, and give fuel suppliers and consumers a clear set of rules they can rely on. Within that framework, I will turn to the evidence that we present as part of our case, particularly the evidence regarding the specific changes that our clients have proposed to the rule as originally proposed by the department. So the first issue we are focused on is a deferred implementation schedule. The original proposed rule asked the board to set an effective date of February 1, 2026, and to, as we read it, require full rule implementation of that point. That would be an extremely ambitious schedule, and in fact assumes the board could complete these proceedings in a very short time. I'm not sure if that's practicable. It sounds like the department may now be focused on a July 1st, 2026 effective date. But even that, in our view, allows little time for the department to hire additional staff, finalize the credit tracking system, have third-party verifiers be reviewed and approved, which is really critical for implementation, and for regulatory parties to understand their compliance obligations and develop their own plans around them. So we propose a more realistic approach. Put the rule in effect July 1st, 2026. Should be in time for you to finish these proceedings and get certain things started like registration, fees, making the system available for people to look at, test, debug, that kind of thing. Then we propose that all reporting requirements for both credit generators and deficit generators would begin on January 1 of 2027. However, we would suggest that the generation of deficits in terms of the compliance obligation to balance the books with credits and such, that begin on January 1, 2028. This phased schedule does not weaken the program. To the contrary, it strengthens it by giving everyone, regulators and regulated parties alike, a chance to test systems, resolve errors, and plan ahead. Think of it as a practice year. Fuel suppliers can begin reporting data and banking credits, but would not yet face deficits. Other states have learned this lesson the hard way. When systems go live before they are ready, compliance becomes chaotic, credit markets malfunction, and trust in the program erodes. The evidence will show that New Mexico can avoid these mistakes by adopting a deliberate timeline that ensures that the program is functional from day one. The second issue relates to the carbon intensity calculations and the use of a particular model, the R&D GREET model, to make those calculations. Both the department and our clients propose to use a model known as the R&D GREET model, developed by Argonne National Laboratory, as the starting point to calculate life cycle carbon intensity values. The difference between our positions is that the department proposes to modify the inputs to the model as opposed to using the science and data-based inputs already included within the R&D GREET model. The department proposes some state-specific adjustments, and they'll be explaining their reasons for doing that. But while we appreciate the department's effort in this regard, we believe it's the wrong path. The GREET model is recognized nationally as the gold standard for life cycle analysis of fuels. It integrates things such as farming, processing, transportation, refining, and end uses, and produces a consistent, scientifically sound carbon intensity value. For that reason, we urge the board to adopt the R&D GREET model, unmodified and using the built-in inputs as the tool for calculating carbon intensity values. Similar to the department's proposed rule, our clients have proposed provisions to allow certain variations from the model inputs based upon verified operational data, or a more flexible approach, but subject to department approval and an opportunity for public comment to allow novel fuel pathways to allow some additional flexibility. The evidence will show that this approach is both scientifically defensible and administratively efficient. It avoids disputes over data inputs and will create a transparent and consistent framework, as well as a level playing field for all technologies. The third issue, the setting of the baseline carbon intensity values, or the carbon intensity values for 2018, which are really the starting point for all of the math in the program. As you all know, the statute requires a 20% reduction in fuel carbon intensity by 2030, measured against 2018 baseline values. Those baseline numbers matter greatly because they set the starting point from which all reductions will be measured. Our clients propose using the E0 and B0 baseline values for gasoline and diesel, calculated directly through the GREET model with default values. The evidence will show that this approach ensures accuracy, fairness, and consistency with the statute. Fourth issue are greenhouse gas reduction project credits, or we refer to them sometimes as innovation credits. What we're talking about here are things like carbon capture, sequestration, and air capture that are used to reduce greenhouse gas emissions, and that can be related to transportation fuels used in New Mexico. The original proposed rule deferred applications for these projects until 2030. The department's red line does advance the date to receive applications to July 1, 2026. However, the department's proposal omits application requirements, and important guardrails on project credit applications. So in our view, it's incomplete. These technologies are available today for greenhouse gas reductions, and they have the potential to make substantial contributions to emissions reductions. We urge the board to allow these credits from the program's inception while including necessary application requirements and guardrails. If a refinery captures carbon and that carbon is permanently sequestered, or if a producer invests in direct air capture, those reductions should count for purposes of the program. The fifth issue is the energy economy ratio. As drafted, the rule includes an EER multiplier that effectively gives electric vehicles greater credit value per unit of energy. While we support electrification as one pathway, we cannot support a rule that tilts the playing field in favor of one technology over another. The statute requires technology neutrality, yet the evidence will show the EER multiplier favors electricity while disadvantaging renewable diesel, ethanol, and hybrid vehicles. It assigns a zero carbon intensity to renewable electricity when that's scientifically inaccurate, and it discourages investment in low carbon solutions that consumers may prefer. We respectfully urge the board to eliminate the EER multiplier and similarly fuel supply equipment credits. Let the market decide which technologies deliver reductions most efficiently. That is the essence of a technology neutral market-based program. Issue 6 relates to deferral mechanisms. Deferral mechanisms are required by the statute, and what they're intended to address are situations where the program does go off base and off track. Every credit market has volatility. At times, credit supply may lag behind, creating shortages that make compliance impossible. In those moments, a deferral provision is essential to protect both consumers and the integrity of the program. The department's draft rule makes deferral discretionary in all instances, and it does not focus on major imbalances between deficits and available credits, which have caused problems for other programs. It requires the secretary to consider 8 factors, issue public notices, and essentially it's very discretionary. While well-intentioned, that approach by itself creates uncertainty and politicizes what should be an objective safeguard. We propose a clear and automatic deferral mechanism for certain instances. If there's a 50% shortage of credits based on looking at the data from the prior year, deferral should be automatic. That will give the time for the market to catch up and readjust. If a forward-looking analysis, in other words, a forecast for the next year, shows a 20% shortage, deferral also should be automatic. That level of predictability will stabilize the market and give participants confidence to invest, knowing that the extraordinary circumstances will not cause sudden and controllable compliance crises. Finally, the 7th issue is a process issue, and that relates to the advisory committee and program review. The statute contemplates periodic program review and the use of an advisory committee, and we believe this is an essential. A program as complex and dynamic as this cannot succeed without structured feedback from stakeholders. We propose that the rule give the advisory committee a clear role in program review, including a requirement that the department consult the committee before making adjustments outside of formal rulemaking before the board, as the proposed rule allows in some instances. This will ensure transparency, bring diverse expertise to the table, and help the board and the department identify problems early that might need to be adjusted in rulemaking. Without such a mechanism, the program risked drifting in one direction, favoring one technology or another without adequate oversight. With our approach to the advisory committee process, the board will have a durable tool to maintain fairness, neutrality, and adaptability. In closing, Madam Chair and members of the board, you have an extraordinary responsibility here. You must design a rule that is workable, that protects consumers, and that gives New Mexico a clean fuels program worthy of trust. Our clients support that goal. As I said before, we're not here to oppose the program. We simply ask that it be designed in a way that is science-based, predictable, and fair, consistent with the statutory requirements. And our members are offering their expertise and experts with expertise in program implementation to help with that. By adopting a realistic implementation schedule, relying on the GREET model, setting fair baselines, recognizing carbon capture, eliminating the EER multiplier, ensuring objective deferral provisions, and empowering the advisory committee, this board can create a program that succeeds where others have struggled. You have the opportunity to create a clean fuels program that works for all New Mexicans. Thank you in advance for your time and for your careful consideration.
Thank you, Mr. Mullenberg. Let's see, Mr. Tucker. Thank you. Oxy reserves. Mr. Wexler. All right, that's American Fuel and Petrochemical, also reserves. All right, I think at this point then, we'll turn to our first witness. Ms. Miano, would you please state and spell your first and last name?
Michelle, Michelle. Last name Miano, Miano.
Thank you. Do you swear or affirm you will tell the truth?
I do.
Thank you. Go ahead, Ms. Sona.
Thank you. Director Miano, to get us started, I'll ask a few questions. Can you share where you are currently employed?
I am employed at the New Mexico Environment Department.
And what role do you hold with NMED?
I am the director of the Environmental Protection Division.
How long have you served in this role?
Since January 2023.
And at a high level, what are your job duties?
I oversee the air quality, radiation control, and climate change bureaus. I'm responsible for ensuring they have adequate resources and budget for their programming. I also work closely with the Office of the Secretary to develop public policy and ensure that the department's strategic goals are met.
What has been your role specifically for this CTFP rulemaking?
I have overseen the Climate Change Bureau's development of this rule and have checked in with them at various points throughout the project, and am ultimately responsible for this rule as it's presented by the department.
With that, is it fair to characterize that you have a solid and comfortable level of familiarity with the CTFP, but you wouldn't say that you're an expert on all of the nuanced details?
Yes.
Director Miano, where did you work before NMED?
I worked at the law firm of Barnhouse, Keegan, Solomon, and West.
In your current role as Director of the Environmental Protection Division, do you represent NMED as an attorney?
I do not.
Are you representing NMED as an attorney in this hearing?
I am not.
Have you previously testified as an expert before?
Yes.
Is NMED Exhibit 5 a copy of your resume?
Yes.
Is NMED Exhibit 4 a copy of your written narrative testimony?
Yes.
Do you adopt under oath today NMED Exhibit 4 as your testimony?
Yes.
Have you prepared a summary of that testimony to share with the board today?
I have.
Thank you. Please go ahead and share your summary.
Good morning, board members. My name is Michelle, and as previously stated, I serve as the Director of the Environmental Protection Division in the New Mexico Environment Department. It is both an exciting and a critical time to be serving in the Environment Department, especially in this division. Our Environment Department, and I say our, over the past 6 years, has evolved from a traditional, modest command and control operation to one that is at the forefront of adding to and diversifying the state's economy and creating space for new technologies to thrive in our region. By way of example, the Environment Department, for the first time, has a senior advisor for economic development, providing specialty support for companies interested in bringing business and expanding different kinds of business to New Mexico. We also now have 14 climate staff in the Climate Change Bureau. 6 years ago, there was no Climate Change Bureau. And when I first started, there were 2 employees that reported to our bureau chief. Let me tell you, evolution here does not happen in bureaucratic decade blocks with this team. We are experts growing and tackling one of the largest issues of our lifetimes, climate change, while helping New Mexico economically grow and diversify. Enter the Clean Transportation Fuel Program legislation, which passed the New Mexico legislature and was signed into law in 2024.
Ms. Director Miano, keep it slow. And if you would pull the microphone just a little bit closer to you.
Certainly. This was legislation the Environment Department had tried to bring for several years in a row. And in 2024, we finally succeeded, a true team effort. Both oil and gas companies and environmental organizations stood in support. The agreed upon program, the CTFP, Clean Transportation Fuel Program, works like this. It evaluates the greenhouse gas emissions of transportation fuels using what's called carbon intensity. For purposes of the CTFP, carbon intensity refers to a measurement of the complete carbon footprint of the transportation fuel, or even more specifically, the life cycle greenhouse gas emissions of a transportation fuel from all points along the supply chain. Carbon intensity measurement is one of the globally accepted ways that industries, and in particular the fossil fuel industry, measures their greenhouse gas emissions for purposes of achieving accurate greenhouse gas reporting and targeted greenhouse gas decreases. Carbon intensity is the grade by which all transportation fuels will be evaluated in this program. The CTFP law requires a schedule of annually set carbon intensity standards against which the carbon intensities of all the transportation fuels produced and used in the state are measured. Fuel producers in and importers to New Mexico that make available transportation fuels that meet or fall below the CTFP's carbon intensity standards, i.e., lower carbon transportation fuels, they earn credits in the CTFP market. The fuel producers and importers that exceed the CTFP's carbon intensity standards, i.e., higher carbon intensity fuels, are allowed to produce and import their fuels. However, they must purchase CTFP credits to do so. In this way, the CTFP incentivizes lower carbon fuels to be produced and delivered, and incentivizes those higher carbon fuels to find ways to decrease those carbon footprints. The law states, quote, "The board shall promulgate rules to implement a CTFP no later than July 1, 2026, end quote." Almost the next day, after this legislation was signed, the Environment Department climate team assembled our experts for the rulemaking. This includes air and climate scientists, economists, public policy leads, attorneys, academic experts, and then in good public policy fashion and skillful public policy fashion, we surrounded ourselves by others, state leaders, industry leaders, environmental advocates, petroleum marketers, and we listened and learned. We first convened the Clean Fuel Advisory Committee, comprised of very different interests, including many of those who are appearing in this case, back in June and July 2024, last year. This group produced the Clean Fuel Advisory Technical Report and presented the Environment Department with a wide range of topics and positions for consideration. We then tapped the expertise of the Pacific Coast Collaborative, a consortium including 3 states on the West Coast that have been implementing similar programs, for their expertise. And when Climate Change Bureau Chief Claudia Borchard and I traveled to our first in-person Pacific Coast Collaborative meeting in Sacramento, our knowledge of this market program quickly deepened and was followed up by regular in-depth meetings. The Environment Department conducted a massive outreach effort. It held group meetings, one-on-one meetings, public meetings, working group meetings, adding to the work done by the Clean Fuel Advisory Committee. We poured over, and I can honestly say, every single page of submission of the Clean Fuel Advisory Technical Report and feedback in response to our draft discussion rule that was published over 10 months ago. Over all this time, and with the benefit of all these discussions, this Environment Department climate team has quickly become members of one of the most exclusive clubs in the world, the experts on the Clean Transportation Fuel Program. Before you is the only set of rules representing a program in which the drafters read and meticulously evaluated each and every one of the comments the department received, from the American Petroleum Institute to the Coalition for Clean and Affordable Energy. The principles in the department's rules are and were carefully selected as part of a program stand-up effort. All of the witnesses from the Environment Department that you'll hear from during this hearing, all of them were directly involved in this rulemaking at some level of the clean fuels market proposal. Full transparency, no black boxes. And as you'll hear, we are delivering the rule we've promised from those early legislation days, a New Mexico specific rule from which New Mexicans will see the benefit. We have a New Mexico specific model derived from the Department of Energy's GREET model. And I'll define GREET for you because it's going to be an important piece. GREET stands for Greenhouse Gases, Regulated Emissions, and Energy Use in Technologies, GREET model, to assess the life cycle analysis environmental impacts associated with technologies, fuels, products, and energy systems across various stages of the supply chain. A state customized GREET is what every other state program uses. We also include consumer cost mechanisms, including the ability for clean fuels credits to be earned on ever important infrastructure components. This part of the program is known as Fuel Supply Equipment Credits, or FSE. This is a key component that incentivizes the enabling of the clean fuels into the New Mexico marketplace. We created these policy hallmarks for the New Mexico program, all while retaining alignment with existing clean fuel programs in other states as directed by the CTFP law. For an Environment Department rule, this is a unique program. At its core, it's an economic engine for clean fuels, climate tech, and advanced technologies. As all policymakers know, oil and gas is an important industry for our state, yet it is finite, and as set forth in the most recent report from our Economic Development Department in my testimony, referenced in my testimony, our economic health as a state depends on adding to existing industries, new industries to the state economy over time. In issuing this rule, we have heard from a lot of them looking to come here, and the ones that are here, even those that are oil and gas, are looking to decarbonize. This program achieves that. As for the climate and health impacts, although not a silver bullet, this program is a key transitional component to complement existing transportation decarbonization efforts in the state of New Mexico and has the co-benefit of reducing air pollution from our streets and neighborhoods. Clean fuels exist today that can do this, and we as New Mexicans want to access them. Specifically, this policy overlays on another complementing policy, the new motor vehicle emission standards that the board adopted in November 2023. As you recall, these rules require vehicle manufacturers to deliver increasing numbers of new inventories of low and zero emission vehicles to the state without requiring any New Mexican purchase any particular vehicle type. Although the federal government has attempted to invalidate those rules, those unprecedented and illegal federal actions are aggressively being challenged by a multi-state coalition, including other states that adopted those rules, and including our own New Mexico Department of Justice. No court has stayed those rules, and thus we consider those rules in our testimony as part of the current rulemaking. And that's not the only complementing policy. New Mexico has the Energy Transition Act to obtain cleaner electricity, the Transportation Electrification Act that affects electricity fueling for battery electric vehicles and plug-in hybrid electric vehicles. We as a state are utilizing our own purchasing power to transition our state vehicle fleet while building a workforce with programs to foster clean energy infrastructure investment and resilient communities. All of these transportation policies work together to decrease greenhouse gas emissions and have the co-benefit of decreasing air pollution. This CTFP program is an essential framework in supporting that overall effort. Thank you for your time, and for these reasons and those presented in my testimony and that you'll hear throughout the Environment Department in this hearing, I urge you to adopt this program.
Thank you, Director Miano.
Madam Hearing Officer, as a point of clarification, during the pre-hearing conference, you indicated that you would be requesting of the board whether it was going to question the witnesses first or whether we'd move into cross-examination. For Ms. Miano's benefit, I was hoping we could put that conversation around now.
Yes, so the board will ask its questions after the parties have asked their own. Thank you.
Okay, thank you.
We're ready. Will you be offering exhibits or?
Well, that was a matter that we had also discussed during the pre-hearing conference. Unfortunately, the parties were not able to come to any sort of understanding to stipulate to the admission of exhibits. For Ms. Miano's testimony specifically, we do want to offer those exhibits. If it would benefit folks to have that in now or after her questioning, we're happy to do either.
Why don't you offer them now?
Sure. So I would like to offer for inclusion in the record NMED's exhibits 4 through 11, 4 being Director Miano's testimony, 5 being her resume, and exhibits 6 to 11 being documents specifically referenced in her testimony. And so I would move for admission of those into the record.
All right, thank you. Let me ask, instead of going through all 18 names, let me just ask you to speak up, raise your hand, or raise your virtual hand on the platform, and you can let me know, Luis. Are there objections to NMED exhibits 4 through 11? I'm not hearing objections. Okay, exhibits 4 through 11 are admitted. Thank you. All right. Are we ready to turn to cross-examination?
Madam Hearing Officer, I do believe it would also be beneficial for us to also move for NMED exhibits 1 and 2 being included in the record. Those would be NMED's clean version of the rule and 2 being the red line natured portion of its proposed rule.
All right. Do I hear objections to NMED exhibits 1 or 2? I'm hearing no objections. Exhibits 1 and 2 are admitted.
And lastly, Madam Hearing Officer, the compilation exhibit that is NMED's Exhibit 3 is a compilation of the rules, statutes, and other laws that are cited in the regulation, as well as the statutory authority for this rulemaking. We did receive some concern that those exhibits are law, and so they're not necessary specifically for exhibits. However, we would still like to offer them in the interest of them supporting the rule that NMED has proposed, as they will be specific documents required when filing with the for publication.
All right. Objection to the admission of exhibit 3. I would tend to agree that although law doesn't need to be made an exhibit, I think it's more convenient for the board members in particular. Objections? Okay, exhibit 3 is admitted.
Those are all of our exhibits we seek to admit this time. Thank you, ma'am.
Thank you very much. We did agree to an order of cross-examination in our pre-hearing conference, and I'll start with Mr. Molenberg or Mr. I'm sorry, yes?
Madam Hearing Officer, I just had a quick question if NMED was going to present their witnesses as a panel?
So what they said in the pre-hearing conference last week is that Director Miano would be presented first, and then there would be 2 NMED panels, and we'll hear about that when we have completed our questioning of the director. All right, I see Mr. Trujillo at the podium. Ms. Sona, do you have something else?
Yes, Madam Hearing Officer, just a point of clarification. Had we discussed the party HF Sinclair going first, followed by the American Petroleum Institute and the New Mexico Oil and Gas Company? Or was that for all other order presentations?
So the request as to HF Sinclair was that they follow American fuel and petrochemical manufacturers. At least that's the little arrow I drew during our pre-hearing conference.
Okay, thank you for the clarification.
Madam Hearing Officer, HF Sinclair would like to go first or if that.
They would?
No, I'm saying if they would. I don't mind them first.
Mr. Boutier?
Madam Hearing Officer, you have it correct. So when the oil and gas is going first,
we need a microphone on you, Mr. Boutier. These hybrid hearings. Yeah.
Thank you, Madam Hearing Officer. Stuart Boutier for HF Sinclair. You are correct in the order that you've outlined this morning. It's when we're going in the reverse order that HF Sinclair would be first before Namoga.
All right. Thank you. Mr. Trujillo, do you have questions of the director?
Madam Hearing Officer, I do. Morning, Ms. Miano.
Good morning.
I'm going to violate, you went to law school, correct?
I did.
I think I'm going to start by violating the rule that briefly to understand something. I'm going to ask you a couple of open-ended questions for clarification. If that's all right.
Mr. Trujillo, I think you need to speak into the microphone.
Sorry about that. Ms. Miano, I'm going to ask you a couple of open-ended questions because I want to get some clarification on a couple points. Ms. Miano, there's no definition of technology neutral in the statute, correct?
Correct.
Ms. Miano, in the proposed rules that you guys, being the department, put forth, there's no definition of technology neutral, correct?
Correct.
Thank you, Ms. Miano. Another open-ended question. Based on your testimony, Ms. Miano, does the department have a new mission of economic development?
It is one of our goals for the next 2 years to add 750 jobs to the New Mexico economy.
Ms. Miano, you have your testimony in front of you?
Yes.
I'm going to give you some pages. I'll summarize the way I did, but I'll tell you what page it's on. I'm sure you're pretty familiar with your submitted testimony. On page 5 of your direct testimony, you indicate that oil and gas companies are already doing work in lower carbon fuels, correct?
I'm sorry, they work
In lower carbon fuels. Is that correct?
Correct.
And that comes with the cost of the companies, correct?
I can't answer that because I don't know how the companies take advantage of certain tax credits or incentives or how they make those decisions.
Is there a witness that's going to be presented on your side that will be able to help me understand that?
I'm sorry, understand what?
The answer to the question that you said you couldn't understand, that it comes at a cost to oil companies?
Is the question, I'm sorry, can you restate the question?
I'll restate the question for you. On page 5, you indicate the oil and gas companies are already doing work in lower carbon fuels, correct?
Correct.
And that comes with the cost to the companies, and you said you couldn't answer it. I was just curious, is there another witness that you're going to present on your panel that would be able to answer that question for me?
No, we don't have a witness talking about the inner workings of company books.
So then that would be something that probably the board should pay attention to the Oil and Gas Association, or I'm sorry, NMOGA and API's witnesses that have that kind of experience.
I don't recall that being in the oil and gas company's testimony.
Ms. Miano, on page 8, I believe, I think this is actually a quote. You indicate, in addition, NMED has recognized that there's much confusion between the CTFP and the cap and trade, cap and invest programs in states like California and Washington. You see what I'm referencing there?
I do.
Again, open-ended question for you. Truly curious, where is this confusion coming from?
We met with the petroleum marketers and presented at the Petroleum Marketers Association recently, and they had been confused that the Clean Fuels program was actually a cap and invest program. And so we made that clarification as part of our presentation and discussion with the petroleum marketers, and they seemed quite relieved.
I appreciate that clarification. One more follow-up question, just to make sure it's clear for the record. You weren't referencing NMOGA and or API as being confused, correct?
They have not indicated. American Petroleum Institute and New Mexico Oil and Gas did not seem to be confused. When we met with them, it seemed to be primarily the petroleum marketers.
Thank you, Ms. Miano. If you could turn to page 10 for me. See you see the part where you're talking about the federal waivers used to support California having more stringent air standards?
Yes.
We're on the same page there?
Yes.
So the federal waivers, the federal waivers used to support California having more stringent air standards was the subject of a recent Congressional Review Act revocation, correct?
Correct.
So those programs are no longer law, correct?
That is.
Ms. Sona?
Oh, yes, I'm sorry. I forgot.
Thank you. Council is asking the witness to make a legal conclusion, and Ms. Miano has stated that she is not an attorney for purposes of this hearing, and she is not representing NMED in this hearing.
All right, thank you.
Madam Mayor, let me ask some additional questions. I'll withdraw that question to give a little foundation.
Go ahead.
As a part of your job, Ms. Miano, do you deal with passing legislation at the state level?
Yes.
And you know what it is for a bill to be passed or a bill to be repealed or sections of the law?
Yes.
Are you familiar with it on the federal level?
Yes.
So I'd ask my question again that I referenced earlier. The federal waivers used to support California having more stringent air standards was the subject of a congressional review revocation, correct?
Yes.
So these programs are no longer law, correct?
All right, there you go, Mr. Trujillo, right there. I'll sustain the objection right at that point because the meaning, if you will, or the impact, the consequences of the legal analysis that would be done of what happened on the federal level and its impact on the state level, I think she would have to be offering legal counsel.
I'll withdraw that question. Thank you. Ms. Miano, on page 10, there's a quote there from Shell Oil. You see that quote? Shell Oil acknowledged that adoption of CTFP.
I remember it in my testimony and I can't find it.
I believe it's page 10 if my reference is correct. Is there a footnote maybe?
Shoot. Oh, it's on page 5.
Isn't it true that that statement by Shell Oil, there was a part of it that was left off that indicated in the complete quote, maybe, I don't know if you're aware of the complete quote. Let me start there. Are you aware of if this is a complete quote of what the company said?
This came from a interview, and so there was quite a big conversation about the New Mexico program and Shell Oil's potential involvement in it. So yes, there is more.
I believe that particular quote indicated that the rest of it was if the program is implemented correctly. Are you aware of that?
It seems plausible.
Council is referencing evidence that's not in the.
Okay, but he asked her, was she aware? And she seemed to have an awareness of it. So that's overruled. Go ahead, Mr. Trejo.
I'll move on, Madam Chair. Thank you. Ms. Miano, in the department's proposed rule, fuel supply credits do not apply to all transportation fuels, correct?
I believe they apply to alternative fuels, but I can defer to my colleague Claudia Borchert that has the most knowledge of all of the different provisions and how they apply to what areas.
Thank you. Ms. Miano, you acknowledge that oil and gas companies are working productively on lower carbon fuels, correct?
Correct.
And you would agree, wouldn't you, that project credits would encourage these further efforts of lower carbon reduction?
Yeah.
Would further encourage these efforts of lower carbon fuels?
Yes.
Ms. Miano, you have engaged with NMOGA and API regarding at least some versions of the proposed rule. I think more recently a complete version. Is that correct?
Yes, we've had many meetings with American Petroleum Institute and the New Mexico Oil and Gas Association.
And how many is many?
Gosh, I would say over 6.
Not sure.
Yeah, there's so many I can't recall the exact number.
And as a part of those meetings, you understand, correct, that NMOGA and API are trying to improve the rule, correct?
I think they're trying to improve the rule in the matters that they represent interests, like everybody's entitled to represent interests for their own memberships.
Ms. Miano, did you hear some arguments earlier from your council talking about a recent meeting with NMOGA and API?
Yes.
So let me ask you a couple of questions before I go back to that specific meeting. You're not an engineer, correct?
Correct.
Not an economist, correct?
Correct. I have one on my team and a very good one.
That leads to my next question. Thank you. Your testimony that you've given, do you consider yourself to be an organizational witness?
I consider myself to be an organizational witness and the person that's responsible for the department's rule ultimately.
And Ms. Miano, you effectively in that capacity gather a bunch of comments from different technical people and present it to this board, correct?
Correct.
But you have some familiarity with the topics, correct?
Yes, I've been working on this rule for 2 years.
So let's go back to the meeting, the more recent one that your council brought up.
Objection, Madam Hearing Officer. This line of questioning is outside. Got the microphone. I forgot. I apologize. I will repeat. Objection, Madam Hearing Officer. This line of questioning is outside the scope of Ms. Miano's direct testimony. The nature of what counsel shared in oral argument previously is not within the record of her testimony, and so I would object to the line of questioning.
Okay.
Madam Chair, I'll withdraw the question.
Thank you.
Ask it a different way. Have you recently met with the New Mexico Oil and Gas Association and API?
Objection, Madam Hearing Officer. This is the same topic.
Mr. Trujillo, I remember that she spoke about public outreach meetings with NMOGA and API, but that does seem to be different from the meeting Ms. Sona referenced.
Madam Hearing Officer, it's my contention that it is the same ones that she's referencing as a part of the outreach effort.
Okay, so let's hear from Director Miano on that.
I have met with my team and also the American Petroleum Institute and the New Mexico Oil and Gas Association many times, which led to this filing on September 2nd of my direct testimony. And then we, Environment Department, had subsequent meetings after I filed my testimony with American Petroleum Institute and New Mexico Oil and Gas Association about the rules.
And let me see if I can ask a little bit. So was it one of the last meetings you had with the two organizations last week or this week?
Objection, Madam Hearing Officer. This line of questioning goes into matters that are more served for rebuttal. They're beyond the scope of the testimony provided on September 2nd.
Mr. Trujillo.
Madam Hearing Officer, we'll go ahead and draw the question, deal with it and rebuttal. If I can, check with my co-counsel real quick and make sure I'm not missing any other questions. Otherwise, I'll be done.
Thank you.
Madam Hearing Officer, I have no further questions.
Thank you, Mr. Trujillo. That was well within the 30 minutes allotted. And I don't think I said this earlier to the board members. I am keeping track, even if I'm not saying it. The witnesses have 30 minutes, up to 30 minutes to summarize their pre-filed written testimony. Each party has up to 30 minutes to cross-examine each witness. And then my memory is that redirect was limited to 10 minutes. So, Mr. Tucker, do you have any questions on behalf of Oxy?
Good morning, Ms. Miano. Aaron Tucker on behalf of Oxy USA. Ms. Miano, on page 3 of your testimony, you address the statutory directives of the CTFP. Exhibit 8 is a copy of House Bill 41, which sets out the statutory directives, correct?
Correct.
Specifically, Section 4C of House Bill 41, this is page 8, lists the 10 key statutory directives for the CTFP.
Yes.
Do you agree that the EIB is required to adopt a final rule that implements all of these directives?
Yes.
Okay. Let's take a minute to walk through some of the directives. HB 41 requires the EIB to establish a rule that is technology neutral, correct?
Can you repeat the question? Sorry.
Sure. House Bill 41 requires the EIB to establish a rule that is technology neutral.
It establishes, or it has a directive looking at page 8 to establish a statewide technology neutral clean transportation fuel standard.
And HB 41 requires the EIB to establish a rule that decreases carbon intensity at least 20% below 2018 carbon intensity levels by 2030.
That is correct.
I'd like to turn to section 4C3. Could you please read that section?
C says the Clean Transportation Fuel Standard Program rules shall establish technology neutral mechanisms for generating, obtaining, trading, selling, and retiring credits among transportation fuel producers, fuel distributors, and other individuals or entities in the transportation fuel market, including additional credit opportunities from activities and projects that support the reduction or removal of greenhouse gas emissions associated with transportation in the state.
Thank you, Ms. Miano. Do you agree that HB 41 requires the final rule to include additional credit opportunities for both reductions and removals?
It says projects that support the reduction or removal of greenhouse gas emissions.
What is the difference between a reduction and a removal?
Well, there's a lot of different ways to look at it. For a reduction, we look at different ways that you could reduce you could reduce the greenhouse gases along the supply chain at various points based on new technologies or different ways of transporting fuel from one place to the next. Oftentimes, removal is thought of in the terms of actually removing greenhouse gases from the atmosphere. A general example of that would be direct air capture.
Thank you. Does the rule define reductions?
Not that I recall off the top of my head.
Does the rule define removals?
Same answer.
Section 4C3 requires additional credit opportunities. Do you believe this imposes an affirmative obligation on the department to provide credit opportunities?
It's something that we have decided to include in this rule. And so I would say that we have included it in the rule, and that helps fulfill this particular provision.
All right, thank you. I'd like to discuss the type of activities and projects that could. The type of activities and projects that qualify for credit opportunities. On page 6 of your testimony, you mentioned the retention of the 45Q tax credit for carbon capture and sequestration. Is carbon capture and sequestration form of reduction that could be eligible for a project credit?
You know, we have not gone into significant depth as far as the project credits and what could qualify or not qualify, because they're, from what we understand from other programs, very specific to a company's project and very time intensive for the department to evaluate. That said, carbon capture could be one of the technologies used for a project credits. We would welcome a carbon capture application.
Does MED's draft rule explicitly identify carbon capture as sequestration as a type of carbon reduction activity that could be eligible for a project credit?
I don't recall we included that specifically, that meaning carbon capture, because the list is so long, we didn't want to leave out something, so we kept it acceptable on the implementation date of July 1, 2026. And we did not expressly put in particular technologies or project applications that we would accept or wouldn't accept, because it would be too many and we didn't want to inadvertently stifle somebody's innovation if they had a project they wanted to submit for.
So the draft rule doesn't identify any specific types of activities or projects that could qualify.
Correct.
And earlier you mentioned direct air capture as a form of carbon removal.
Yes.
Direct air capture is not listed as an eligible type of project credit, correct? In the rule?
Correct. Yeah, we did not identify specific project examples in our rule.
NMED made some changes to the project credit section from the petition draft. Specifically, NMED moved up the date from 2030 to 2026 for the department to accept applications, correct?
Correct.
What was the basis for that change?
Well, there were several bases for it. I think we originally wanted to defer it because, speaking with the other states, we know that there is so much work that the different state programs go through as part of their mature clean fuels markets, with evaluating these kinds of projects. We originally thought that based on that kind of impact to the program, it would be prohibitive to allow us to get the program up and running. Then we, talked to, frankly, companies or entities like American Petroleum Institute and the New Mexico Oil and Gas Association, and they do have innovations that they want to see and bring as part of our project credit application. So we thought that a good trade-off for us and the workload at the department would be to allow those kind of project credit applications, but in return have the company that is applying for the project credit pay for the evaluation of those different kind of project ideas as part of their fee, almost like the alternative pathway that you'll hear about, so that the department is not depending on the fees from market credit generators and deficit generators for a one-off kind of project like would come in through this kind of project credit. So we thought that we can allow the project credit on the program implementation deadline of July 1, 2026, but that as a trade-off, we would have the companies seeking to participate to pay for that evaluation that we would do likely through a consultant, third-party consultant, as part of their fee for us to evaluate the program specifics.
The statute sets a pretty ambitious goal for 2030, correct?
Correct.
And credits will be necessary to meet that 2030 goal, correct?
Are you referring to project credits or credits, clean fuel credits generally?
Credits generally.
Yes.
And project credits are one of the two ways that credits can be generated.
Yes, that is correct. And we heard the concerns of the American Petroleum Institute and New Mexico Oil and Gas Association. They had identified that there might not be enough credits over time. And so that would be another help for credit generation in the market.
You mentioned discussions with stakeholders around the project credit section. Were there any other concerns raised about the project credit section?
Well, we did learn from the September 2nd filings from the Coalition for Clean and Affordable Energy that the coalition also likes and favors project credits. They favor project credits for public transportation projects, it seems, and other kinds of projects that they would like to see. And so it seemed like there was a general acceptance of project credits being used for different transportation decarbonization purposes.
Did industry stakeholders raise the issue that direct air capture and carbon capture and sequestration were not listed as examples of project credits?
Objection, Madam Hearing Officer. This line of questioning, I feel, is getting very topical outside the scope of Ms. Miano's testimony. And so I just respectfully ask that it stay within the scope of the broad nature of her testimony.
Director Miano, does the department have another witness who will be addressing this topic?
Yes, our witnesses include Claudia Borchert, who will be addressing the specific rule provisions, as well as my testimony.
So, Mr. Tucker, would you reserve for Ms. Borchert?
Yeah, and I just have a couple more questions if I could just finish this line of questioning, just on her kind of the stakeholder engagement process.
Okay.
Would you like me to repeat the question?
Yes, again, honoring the fact that Ms. Miano did describe the engagement process, but not going to the specific rule provision that Ms. Borchert will be testifying about.
Okay. Then I'll move on to the next question. Has anybody committed to make any additional changes to the project credit section?
Well, we understand that there are changes that the American Petroleum Institute and New Mexico Oil and Gas Association would like to see some more specifics other than allowance for project credit applications starting July 1, 2026. And so we're open to a conversation to figuring out what detail could be a resolution of not only industry side, but also the Coalition for Clean and Affordable Energy side too.
Are there any other changes that you're considering to the project credit section?
Objection, Madam Hearing Officer. This is not within the scope of Ms. Miano's testimony.
Well, it kind of goes to the the iterative process that we see in so many complex rulemakings. So if it's something you can answer right now, that's great. If it's something the department is reserving for rebuttal, that's great too. whatever answer you want to give.
Yeah, I'll just add, we're not considering for this rulemaking anything other than, we have seen, like everybody else has seen, the red lines that have been submitted as part of the September 2 technical testimony filings. So those would be the only considerations that we would be looking at for this round.
Okay, one last question. Would the rule provide more regulatory certainty to project credit applicants if it explicitly listed types of qualifying types of projects?
Madam Hearing Officer, objection. This witness is established. She is not the expert for project credits. She is speaking high level. This is better reserved for another witness.
All right. Is that true, Director?
Yeah, we can talk about it with Claudia Borchert, perhaps.
All right, I'll rest. I'll pass.
Thank you so much, Mr. Tucker. It is now 11:56. So we'll take an hour and 4 minutes for lunch. We'll return at 1 for public comment, and we will pick up Director Miano's cross-examination after public comment. Someone has something on that needs to be muted. Mr. Wexler, I'm sorry, you need to be a little closer to the microphone. Okay. Or it needs to be a little closer to you one way or the other.
And I'll say, it had been communicated to me that I was too soft in my communication, in my testimony. So if I'm overcompensating by shouting at you, let me know. That's not my intent.
Do you have before you your Exhibit 5? That's your CV.
Yes.
My understanding is you have a bachelor's degree in writing seminars.
Yes.
And then you got your JD from UNM in 2014.
Yes.
Do you have any other degrees?
No.
So you don't have a degree in economics
No.
or accounting?
No.
Economic policy?
I don't have a degree in economic policy.
Do you have a degree in any scientific discipline?
I don't have a degree in any scientific discipline, but I did participate in law school in the Environment and Natural Resources Law program.
Is that considered to be a scientific discipline?
No, but it is a study of the major environmental laws of our country.
Mr. Wexler, I'm sorry to interrupt again. We're being told by folks on the platform they really can't hear you.
Okay. Try that. You acknowledged when you were being asked questions by Mr. Trujillo that you are not an economist. Is that right?
That is right.
And I mean, we can go through your various professional positions, but you've never held a position where you were responsible for conducting an economic analysis of policy positions. Is that right?
I have not, but I have a great team behind me that can.
Understood. Is it fair to say then, based on that statement, that you are not an expert in economic analysis?
I am not.
Objection, Madam Hearing Officer. She has answered these questions in several formats. I understand the line of questioning, but they're the same questions.
Actually, it's not the same question, because now I'm asking this witness whether she considers herself to be an expert in economic policy. That's relevant.
Understand. Go ahead, Ms. Miano.
I do not consider myself an expert in economic policy.
If you turn please to your testimony exhibit 4, and I just want to start at the bottom, page 1. There you indicate that one of the purposes of your testimony is to broadly explain how the CTFP is an added benefit to New Mexico's economy. Is that right?
That's right.
And then on pages 5 through 8, you have a section of your testimony entitled Adding to the Strengthening New Mexico's Energy Economy, right?
Yes.
Is it fair to say that testimony on those pages relates to the economic impact of the proposed CTFP rules?
I don't think it's limited to the economic impact of the CTFP rules. I also include the Economic Development Department's most recent report as well. And our department works with them and other agencies quite closely.
So then, if I understand what you're adding is you also include information about economic development, is that right?
I include information about state strategy of the state's economic goals.
Are you an expert on the state's economic goals?
I participate greatly in their development and help the Economic Development Department a lot with new industries coming to New Mexico. A lot of times we have to learn about the different technologies, different permitting requirements, and as a state, we generally work together, agencies work together in order to attract new businesses to the state for the benefit of our residents.
Understood. I appreciate that. My question was a little simpler. Do you consider yourself an expert in economic development?
I consider myself very experienced in the goals of economic development under the current state policies and what we're trying to do as a state to bring in advanced energies, new climate tech programs. I recently had a conversation with the Economic Development Secretary about the new New Mexico State Investment Council reorganization on their capital venture program to attract new businesses and provide different stages of capital to companies interested in locating to New Mexico, many of which are seeking to take advantage of the incentives of the Clean Transportation Fuel Program credits. We also do a lot of outreach with companies that are interested in learning where they can locate. So I'll connect them with my colleagues over in the new Economic Development Department, Technology Innovation Office. We do events together, and our Secretary of the Environment is very much involved in coordinating with our executive team in making sure that we're doing everything we can as an environment department to enable and not hinder new businesses coming to the state.
It was a long answer. I'm not sure I heard the answer to my question, but let me try this. Given your background and experience, the fact that you're not an economist, don't have that expertise, I understand you're relying on the testimony of other NMED witnesses for any economic analysis in your testimony on those pages 5 through 8?
Well, they definitely added to my understanding, but as a director in the environment department, as I just discussed, our environment department is really taking a different role than traditional environment department activities of the past in order to make sure that we're attracting new businesses to the state and working
an interagency collaboration to make sure that occurs. And so I've amassed quite a bit of knowledge, not just from our economists, but from my experience over the past 2 years in my position as the state is pretty aggressive in bringing in and trying to attract new businesses to our region.
Are you or are you not relying on other NMED witnesses for much of the testimony in pages 5 through 8?
I think that one of the things that I am grateful to have is an economic team that can speak to the mechanics of the market. I don't need our economic team to, for example, on the pages that you reference, understand that many major oil and gas companies are publicly highlighting their work on innovation in lower carbon fuels, such as renewable diesel. That is something that they themselves have presented and something that we have conversations about, separate and apart from the economic team that helped inform the rule and how it works and its mechanics.
So there's some part of that testimony which you have personal experience about.
That is correct.
Let me ask you about that oil and gas comment that you had. And elsewhere in your testimony, you talk about the legislation being supported by oil and gas companies. Is that right?
The legislation was not supported by all of them, but by several of them.
You're aware that NMOGA, API, AFPM are trade associations representing oil and gas industry?
I am.
Do you know how many companies those trade associations collectively represent?
Quite a few, I would say.
You're aware, I expect from reviewing the documents filed in this case, that those trade associations do not support the CTFP rules in their current form?
Yeah, I was curious about that because we had support from many of the same member companies for the legislation.
Do you know how much money the oil and gas industry contributed directly to the general fund in 2023 or 2024?
Objection, Madam Hearing Officer. This is outside the scope of the witness's testimony.
She's talking about the support for the oil and gas industry. She said during her testimony earlier that the oil and gas company was, quote unquote, important to the state of New Mexico, and I'm trying to explore that testimony with her.
I think it's still though, well, all right, maybe go a little ways. Ms. Miano, just don't forget to stay within your personal knowledge.
Do you want me to ask that question again?
Sure.
My question is, are you aware of how much money the oil and gas industry contributed directly to the general fund in either 2023 or 2024?
Yeah, it ranges, but I believe it's about 40%.
40% of the general fund.
Of the state's budget.
You indicated in your summary of the direct testimony, I believe that the oil and gas industry is important for New Mexico. Did I have that right?
Yes.
Why?
Well, the oil and gas industry does contribute to the general fund, as you just stated.
Any other reasons?
Well, there are, yeah, of course. They have a lot of, they're important job contributors and provide not just oil and gas jobs, but service jobs around the industry as well.
Will you agree with me that it's therefore important to adopt rules that will work for the oil and gas industry in New Mexico?
I would say that it's important for the Environment Department to consider the input of the oil and gas industry, although an important component. And although this particular rule is not intended to replace oil and gas industry in New Mexico, but I would say that it's important for us to understand the industry's perspective and what their input is on these rules. And we have done extensive meetings with them to determine exactly what that is and incorporated quite a few recommendations from oil and gas into our rules. We didn't incorporate everything, but we incorporated quite a few recommendations.
You started your answer by saying that it was important for the Environment Department to consider the oil and gas industry perspective. Is it also important for the board itself to consider the perspective of the oil and gas industry in developing and adopting the rules?
Well, I think the board has a statutory directive that tells the board how to fulfill the legislative intent. And it's up to the board to make that determination. So as the Environment Department representative, I'm presenting the board with rules that have incorporated many of the comments of the oil and gas industry into this draft. And we have rejected some additional recommendations because we didn't think it was in the best interest of the state and didn't fulfill the program. And that's okay. You know, we have to, as an environment department, listen to all different kinds of input and, you know, put together what we think is the best rule for New Mexico.
And I appreciate that, but I assume you understand that the oil and gas industry, of course, is capable of speaking for itself to the board.
I am guessing that's why everybody's here today.
I last have a few questions about, related to your testimony this morning on the advisory committee. Do you recall discussing the advisory committee?
Yes.
Exhibit 1 and 2 are clean and red line versions of the rules that the department is advocating in this proceeding. Is that right?
I believe so.
The version of the CTFP rules contained in exhibits 1 and 2, those were never presented to the advisory committee. Is that correct?
They were not. We have presented them to the board as part of our technical testimony on September 2nd.
But in other words, the department never reconvened the advisory committee to offer comments on your revised proposed rule.
No, we convened the advisory committee at the beginning to inform what would ultimately be this proposal, and many of the provisions that we included in the rule come from the Clean Fuel Advisory Committee technical report. And then we dissolved the committee. We also then set up the draft discussion rules that we published for additional comment on that draft set of rules. And we had, I think, over 100 comments or close to that on those rules. So we went meticulously through that second round. And that also helped inform the rules that we presented to the board on September 2nd. And then in the future, you know, we have already thought about what might go into additional rulemakings, because that's how these programs seem to run in other states. We are in almost a constant rulemaking cycle to make sure the market is working correctly. And so we look forward in future rulemakings to convening an advisory committee and having their input as we move forward on future rulemakings as well.
But of course, by that time that you reconvene the advisory committee, the board will have acted on this set of rules.
Correct. Yes, the advisory committee doesn't adopt the rules. That is reserved for the board under the law.
No further questions.
All right, thank you, Mr. Wexler. Mr. Maxwell, do you have questions of Director Miano?
I have a few questions.
Okay, thank you.
Director Miano, my name is Nick Maxwell. Good to see you again.
Hello.
You testified earlier today on material found in page 10 of your direct testimony, specifically over the action of the federal government, quote, to invalidate the rules on which Section 177 states policies are based, end quote. Is that correct?
Correct.
In your oral testimony today, do you recall describing the actions of the federal government as, quote, illegal, end quote?
Yes.
Are you making that assertion of those actions being illegal on your own opinion?
Objection, Madam Hearing Officer. We've addressed this already. The manner in which Ms. Miano is qualified to offer these types of statements has been addressed.
Yeah. So, Mr. Maxwell, you probably heard the discussion earlier. Ms. Miano is not really representing the department as their counsel, but as a policy level director.
Okay, she testified today of her opinion that the action was illegal. That's what I'm testing right now, is that testimony.
Okay. So, Ms. Miano, do you have anything to add that Mr. Maxwell can explore around that statement?
I would say that that matter at the moment lies with our state of New Mexico Department of Justice, who has filed a lawsuit against the federal government action and questioned the ability of the federal government to take the action that it did in the way that it did it.
Okay, I have two more questions. You mentioned that no stay of the rule has been issued by any court. Is it accurate to say that you are knowledgeable about the current actions taken by any court on this issue?
We are given updates by our attorneys at the department as to how the different litigations are progressing. And one of the updates has been that no court has stayed the California waiver.
To your knowledge, none of these updates have given you any information that any court has rendered an opinion on the legality of the rule.
Objection, Madam Hearing Officer. I believe this line of questioning is going into where it would be attorney-client privileged information that Ms. Miano is being asked to share, in addition to continuing to ask her to opine on the legal conclusion.
All right. So actually, I see the question as more limited than that. Has the director received an update informing her that a court has rendered a judgment on the legality? Was that your question, Mr. Maxwell?
That's my question.
All right. Do you have knowledge of that?
No, the litigation is still ongoing.
Your Honor, that's all my questions. Thank you, Director Miano.
Thank you, Mr. Maxwell. Mr. Boutier or Mr. Harris?
Good afternoon, Director Miano. Can you hear me?
Yes. Oh, I can, but
You can.
it doesn't matter for me.
Okay. How is this? Is this better? Can you hear? Great. Thank you. Director Miano, I only have a few questions. My name is Stan Harris. I'm an attorney and I represent HF Sinclair in this proceeding. First, I have a question regarding your testimony on expected future rulemakings. In your written testimony, you cite to and rely on other states, specifically Washington, Oregon, and California, that have conducted multiple rulemakings. Is that correct?
I observe that they have had multiple rulemakings in my testimony, yes.
Thank you. Are you aware that Washington's additional rulemaking was the result of specific new state legislation that directed specific changes to Washington's Department of Ecology? Ecology.
If I recall, they had changes to their greenhouse gas emissions goals or their carbon intensity. I can't recall because it's matched with their cap and invest program.
If I were to
Correct.
Thank you. If I were to tell you that, or if I were to represent to you that Washington's additional rulemakings were the result of specific state legislation requiring that rulemaking, would you have any reason to disbelieve that?
No.
Because NMED is following Washington's lead, do you agree that it would be good policy for NMED to wait for the legislature to direct NMED to address any claimed additional issues in an existing CTFP program?
No.
Why not?
Because there are so many considerations that we already have to make in the existing legislation. We at the Environment Department believe we have the guidelines to present the proposal that we did, fulfill all of the statutory mandates, and have a successful program under the current framework. That doesn't mean there won't be legislation in the future, but we certainly don't have to wait for any legislation in our state to implement the program that we've presented.
So you would not be following Washington's example in that regard?
I think we would be if the legislature decided to pass legislative changes to the program that changed the guardrails or the guidelines.
Thank you. In your written testimony, I think the last sentence of your written testimony, you state that, and I'll wait till you get there, you state that the proposed rule, quote, positions New Mexico to not prohibit the use of fossil fuels, but to ensure an all of the above energy approach, end quote. Did I read that correctly?
Yes.
Do you think that this all of the above energy approach should include all projects which reduce the carbon intensity of any type of fuel?
Can you give an example?
Of what? Of the type of fuel?
Or an example of a project? Are you talking about project credits?
We could talk about project credits, sure.
Okay, can you repeat the question using project credits?
Sure. Do you think that this, quote, all of the above energy approach, end quote, should include all projects which reduce the carbon intensity of any type of fuel?
Well, I think if it were talking about project credits, we would have to look at what was submitted to us as part of that project proposal and make an evaluation as to what the project presents and if it actually does decrease carbon intensity and greenhouse gas emissions. So we would make that analysis when we receive the application.
That would be with regard to the specific project that had been proposed to you. Is that correct?
Yes.
Look, I guess that my question's a little different. Again, what I'm looking for is, do you think that this all of the above energy approach should include all projects which reduce the carbon intensity of any type of fuel?
Objection, Madam Hearing Officer. This has been asked and answered.
So I think it hasn't been answered because I think she hasn't understood exactly what he's asking.
The last portion of the question, and I understand your first portion, is talking about a project by project analysis of projects that are brought to you. Would the department, under this proposed rule, consider a project that is brought to you with regard to just some types of fuel or any type of fuel that is brought to you? Is there any difference in the department's analysis of the project depending on the type of fuel involved?
I don't know if I completely understand your question, but it sounds like we have covered the project credit scenario. All other scenarios, really, we only look at carbon intensity and we look at that metric no matter what the fuel is. And so it doesn't matter what the fuel is. It's all of the fuels, and we look at the carbon intensity of all of the fuels. And then that is how we determine whether the fuel is above or below that annual carbon intensity standard. So we do look at all the fuels, and then we only use that carbon intensity to determine if it's above or below the standard. I'm not sure if that answers your question.
Thank you. I appreciate it.
Okay.
Just one last question. Do you know how many New Mexico Environment Department staff members will be needed to implement the proposed CTFP program?
Well, we have the wonderful group behind you. So we have about 14 climate change bureau staff now, and we're anticipating to bring on, we have 3 more that we can bring on that we have projected in our budget. And so we feel very comfortable with this first phase of the program that will provide the in-house expertise to get us there. And then for any gaps that we have, we'll be working with consultants that we can bring on as we scale up our in-house capacity.
Does that mean that you're unsure how many staff members you'll actually need to implement the program?
No, we can implement the program by the final implementation date, like the drop dead implementation date of July 1, 2026 today. But there's going to be a lot of build up as the program matures and builds, and we receive alternative pathway applications and project credit applications. We really want to build that in-house expertise as much as possible. So we're anticipating 3 new employees for that purpose in this first roll round.
Thank you. That's all I have.
Thank you.
Thank you, Mr. Harris. Mr. DeSalen?
We have no other questions, Madam Hearing Officer. Thank you.
All right. Thank you, Mr. DeSalen. For Food and Water Watch, Mr. Lodell or Ms. Reno? Oh. Let's see. Mr. Pisaris for the Coalition for Renewable Natural Gas. You were on the platform earlier.
Yes, thank you, Madam Chair. We do have a few questions for Director Miano.
Go ahead. And if actually, I'm sorry, would you spell your name first, please?
Yes, YANNIPSAREAS.
Thank you.
Director Miano, HB 41 directed NMED and the board to establish the CTFP that accounts for a full life cycle.
I'm sorry, Mr. Pisaris, hold on one second. The court reporter is having trouble hearing. All right, and he asks that you slow down, please.
Understood. Thank you. Okay, Director Miano, HB 41 directed NMED and the board to establish a clean transportation fuel program that accounts for the full life cycle of fuels and allows for additional credit opportunities for emission reductions, correct?
Correct.
NMED included avoided methane crediting in the draft rule because it reflects real measurable reductions from capturing methane, correct?
Correct. Correct.
Are you familiar in this previous legislative session, Senate Bill 99, which was introduced to prohibit fuels from receiving a carbon intensity score below 0?
Yes, I'm generally familiar with that bill.
Would you say that prohibiting negative carbon intensity scores would have effectively eliminated avoided methane crediting from the program?
Are you talking about what the effect of that bill would have done?
Yes, on the program. It would have gone into effect before the program was implemented, which I'm assuming would have impacted how NMED would have drafted it.
Correct. That's right.
And SB 99 was rejected in its first committee with bipartisan opposition. Are you familiar with this?
Yes.
And the legislative outcome, did it support NMED's interpretation that avoided methane crediting should remain part of the program?
Yeah, we didn't have a role really in that bill. We knew based on stakeholder meetings that the negative carbon score or the methane avoided emission would be something that our program would likely consider, and conversations confirmed that. And then my colleague Angela Rasso, Dr. Rasso, will be able to speak more about the data informing that. But looking at the environmental attributes, we did see an actual methane reduction and incorporated that piece into the program.
And other programs, California, Oregon, and Washington, avoided methane crediting is within those programs, correct?
That is correct.
And I've in HB 41, which directed NMED and the board to create this program, there was I believe within Section 4, there was a line to consider similar programs in other jurisdictions. Correct?
That's right.
And if avoided methane crediting were to be removed from this rule, would it make it more difficult for New Mexico to meet the targets of reducing carbon intensity of transportation fuels of at least 20% below 2018 levels, and then 30% by 2030, and then by 30% in 2040?
It would definitely impact our ability to meet those requirements, but not by much. From what I understand, our renewable natural gas is very small compared to that of California's, from what I understand. But my colleague, Dr. Rosso, will be able to talk more on the subject.
Thank you, Director. Madam Hearing Officer, I yield my time.
Thank you so much. Has Mr. Nasco joined us?
He won't be joining us tomorrow.
Thank you. Has Mr. Duff joined us? No. Has Mr. Smith, Jed Smith, joined us? No. Ms. Vercruz, do you have questions of Director Miano? Thank you. Mr. Noyes or Ms. Menard?
Thank you, Madam Hearing Officer, Madam Chair, and members of the board. I'm representing multiple parties in this proceeding, so I want to be very clear in terms of the context of each of these questions, and essentially I'm going to switch from one party to another quite deliberately as we move through the questions. These are all very technical points. Want to express the appreciation of my clients, all of my clients, for all the great work that has been done to bring us here today, and also the robustness of this hearing procedure that is second to none from what I can tell. So I'd like to start on behalf of Infinium, just to give the board context for this these questions, and also for Director Miano. Infinium is the world's first company to develop electrofuels on a commercial basis, and electrofuels are essentially the conversion of power into fuels. In Infinium's case, taking that power to produce electrolytic hydrogen through water and then combining that with captured carbon. And so because of the nature of that process, the book and claim provisions are highly critical to Infinium.
Madam Hearing Officer, not a harsh objection, I guess, but it's kind of like an opening. I know Mr. Noyes hasn't gone yet. If he's taking some of that time now, I understand the context, but if he could just keep to the questioning.
Yeah, I started his time a couple minutes ago, so go ahead, Mr. Noyes.
Thank you. So specifically in reference to section 20.2.92.206, those are the carbon intensities for electricity. This is one of the areas where NMED made some changes. And this is specific to the subsection F there. And in that case, the mechanism for book and claim are renewable energy certificates representing the renewable power. And subsection F provided in the petition draft, that is the first draft, that RECs may not be utilized for any other programs. Are you familiar with that provision, Director Miano?
Yes.
Yes. And then in the revised revision, it was changed to state RECs shall not be claimed in the CTFP for fuel reported in any other program that would cause the environmental attribute to be claimed more than once. Are you also familiar with that new provision?
I'm generally familiar with it, yes.
Can you, what was the reason for the change there?
This question might be best answered by my colleague, Claudia Borchert, but generally speaking, we wanted to make sure that we had the ability to keep track of those environmental attributes and where they were being used, and we didn't want them to occur multiple times over multiple states.
And were you also concerned regarding double counting regarding federal programs?
Yes, we did consider that as well.
And specifically, the Federal Renewable Fuel Standard has situations whereby a facility might utilize a renewable energy certificate called a REC, and that could help it generate RINs under that program. Are you aware of that? RINs, R-I-N-S.
Yes.
And the Inflation Reduction Act continues after the statutory changes to have some crediting available for hydrogen under 45B,
yes.
And for clean fuels under 45Z. In the situation of Infinium, that's a company that might use the same REC to reduce its carbon intensity so that it would qualify for 45Z, and also qualify for New Mexico clean fuel credits so long as it met other requirements. Is that a situation where NMED would not want Infinium to be able to receive those federal credits?
I think this question with the technical detail is best answered by my colleague, Claudia Borchert. I know that we considered very carefully the different stacking mechanisms with the Inflation Reduction Act, remaining provisions, and how they worked within our clean transportation fuel proposal.
Understood. And is it your perspective from your work on this program that it could actually be beneficial for the same fuel to receive federal credits, in that that would lower the net cost to consumers of the fuel if those credits were available both on the federal and state side?
I would say that, you know, there is a complex interplay between the federal credits that can be received and this program, and how the mechanics work is best left to Claudia Borchert.
Very good. Thank you. That concludes my cross-examination on behalf of Infinium on that issue. I'd like to move forward to the staff producer group. Thank you. So this has come up previously in your testimony, Director Miano, the question of technology neutrality that was contained in HB 41, and so obviously is a requirement of the legislature. Has NMED developed a definition for technology neutrality?
There is not a definition within our rule. However, the rules themselves do not favor one technology over the other from our position. If there are differences, it's based on the carbon intensity of the fuel or the actual fuel and how it performs within the program, not because it's this particular kind of fuel or that kind of fuel. We're looking very specifically at carbon intensity and if it generates a credit or not.
And so different process technologies could be used to produce fuels, and those would all be eligible if they achieve carbon intensity reductions?
Correct.
Specific to the crediting of fuels, are you in agreement that for alternative jet fuel, that crediting is determined in reference to Table 3 of the regulations?
I believe so, yes. But I'm nervous that I'm not going to be able to particularly talk about Table 3 in the way that you're going to ask.
I will not ask any questions about the numbers in Table 3, and that gasoline is governed by Table 1 and diesel by Table 2.
Sure.
And that the crediting mechanism is essentially the difference between the carbon intensity standard for a particular year and the carbon intensity standard of the low carbon fuel, and that difference is the relative rate of crediting.
That sounds right.
So in the case of the jet fuel and distillate fuel, are you aware that on-road diesel is typically number 2 diesel fuel, and jet fuel is a number 1 kerosene distillate fuel, but also with heightened specifications from a quality controls perspective?
I think that it might be best if you reserved the question for one of our technical experts as far as the tables and the carbon intensities reflected from them.
Okay, I'll move through this quickly, but are you aware essentially that due to the differences between Table 3 and Table 2, alternative jet fuel receives about 10% less crediting than would a diesel fuel with the same carbon intensity?
I am not aware.
Madam Hearing Officer, I think a lot of this line of questioning is going to be best reserved for NMED's witnesses.
As she's saying. Yeah.
Okay.
Go ahead, Mr.
I'm sorry, I did not hear your response.
Just she is telling you the limits of her testimony, and it seems you're respecting it.
Yes. Outside of the tables here, there is one sort of qualitative difference between alternative jet fuel crediting and diesel fuel crediting, in that alternative jet fuel
is an opt-in fuel rather than a regulated fuel. Is that correct?
Yes.
And could you describe the differences between an obligated fuel and an opt-in fuel from a practical purpose?
Yes. An opt-in fuel is a fuel that is not formally subject to the rules as far as credit generation. So if it was sustainable aviation fuel and it was below the carbon intensity threshold and a company wanted to receive credits for that fuel, they would have to opt in to receive those credits and to participate in the program. And it's not something that would be regulated with deficits at the same time.
Thank you. And in the case of a conventional jet fuel supplier into New Mexico, to the extent they're supplying conventional jet fuel and their conventional jet fuel is higher than the standard for a particular year, would they be incurring any deficits and any obligation to comply with the program requirements?
No.
In contrast to that, if a diesel supplier is supplying diesel fuel into the state, would they be incurring deficits and have obligations to comply to meet the standard?
Yes.
So from a regulatory standpoint, gasoline and diesel fuel would be within the standard, which is at 74-1-18C1 from a statutory perspective, whereas jet fuel would be an opt-in situation and is one of the situations that I think was referred to earlier of reduction or removal of carbon intensity as a basis for credit generation. And did I layer too much into that question? Maybe I should rephrase that.
If you just could repeat it, I think I got it. I just want to make sure I'm answering the right question.
Okay. So there's one, the situation for gasoline and diesel, essentially those are fuels that are subject to a CI standard and causing obligations in terms of generating deficits and creating an obligation to obtain credits.
Correct.
Whereas jet fuel does not incur an obligation, and within the statute, it's what would be called an additional crediting opportunity supporting reduction or removal.
Yes.
From a policy perspective, was NMED seeking to provide lesser crediting for alternative jet fuel versus gasoline or diesel fuel as a policy decision?
I would have to defer to my colleagues on that question. I know we thought about sustainable aviation fuel, and it's tricky because of how it's treated in other programs as well. And so I would say that question would be best for one of my colleagues that has more technical knowledge of how the program operates and how we came to that decision.
Understood. And from a general NMED policy perspective and New Mexico policy perspective, is the state seeking to increase the supply of sustainable aviation fuel to the state and to decarbonize jet fuel to the extent feasible?
Yes, absolutely. And I know that there has been discussion about how to treat sustainable aviation fuel in other programs. We, New Mexico, certainly want that because we know there's so much investment happening in that space. One of the things we have been thinking about too is where the best time is for that, whether it's getting the program up and running or whether it's in a subsequent rulemaking. But as a general matter, we very much want more sustainable aviation fuel here in New Mexico.
Thank you, Director Miano. Madam Hearing Officer, Madam Chair, and members of the board, that concludes the SAF producer group. cross-examination, I'd like to move to Verde Clean Fuels.
Please.
Thank you. Verde, VERDE, Clean Fuels. Thank you. So this line of questioning pertains solely to the definition of synthetic fuel that's included, and this is another case where we saw a change from the what I call the petition draft to the revised petition draft that was filed on September 2nd. And related to that, the initial definition in the petition draft was synthetic fuel means a finished transportation fuel produced from synthetic hydrocarbons that are formed through chemical processes by human agency that can substitute for or be blended into fossil fuel. So relative to that definition of synthetic fuel, are you aware that synthetic fuel has been in usage for over a century for transportation applications?
I did not know that.
Were you aware of the one of perhaps the most famous applications there was in South Africa during the period of boycott? Sasol produced coal to liquids fuels through a gasification process.
I did not know that either. That's very interesting.
Are you aware that synthetic fuel, the term within the industry is most typically used to reference gas to liquids fuel?
I did not know that.
Switching gears to the revised petition draft, the second definition was as follows. Synthetic fuel means carbon-based liquid or gaseous fuel manufactured through chemical conversion processes from another carbon source, including electrofuel, synthetic biofuel, power to liquid fuel, power to gas fuel, and synthetic gas. Are you aware that due to the widespread crude oil extraction in the Permian Basin, that those operations typically have substantial methane production that are essentially part of the crude extraction process?
As far as flaring or venting or leakage?
Exactly. Yes.
Is that what you're referring to? Yes.
Yes. And that sometimes the crude oil production is such that there's excess methane capacity in excess of what can be taken away by the natural gas pipeline infrastructure.
Yes, I'm very much aware of that.
And are you aware? Are you familiar with the term gas to liquids or methane to gasoline?
Yes.
And are you aware that methane to gasoline in particular could create significant new economic opportunities in New Mexico for development of those methane resources?
I was not aware of it, but I'm never surprised by the innovation of all of these companies, including yours, interested in coming here for these kinds of reasons.
And regarding sort of the key change between the original definition and the revised petition draft definition, that specifically called out essentially examples. The new language was sorry, I picked up the wrong document there for a moment. The phrase was added, or the final phrase was added, including electrofuel, synthetic biofuel, power to liquid fuel, power to gas fuel, and synthetic gas. And there's not a reference there to gas to liquids or methane to gasoline. Was that a deliberate omission not to make those fuels eligible, or was this just a non-inclusive list that would include other fuels as well?
It was, from my understanding, it wasn't intentionally omitted. And so if we did intentionally omit something, we can discuss how we might cure that. I know we've been getting a lot of input on a lot of provisions with this rule, so.
Thank you, Director Miano.
Thank you.
Thank you, Madam Hearing Officer, Madam Chair, members of the board.
Thank you, Mr. Noyes. Has Ms. Tremblay joined us? No. And Mr. Weatherby, last but not least, do you have questions of Director Miano?
Madam Hearing Officer, can you hear me okay?
Yes, I can.
All right, thank you. First of all, thank you for running a good meeting, hearing. And good afternoon, Ms. Miano. Let me first thank you for the work you do for the people of New Mexico. I know as a state employee, many times people don't get recognized for the efforts they put in. And regardless of people's opinions on a particular matter, it's really good to respect the people who do the work every day. So thank you. My first question is, in your testimony, you wrote that the CTF is a balanced market-based approach. Can you provide a definition or point to a citation of or a definition of market-based approach or a balanced market-based approach?
The phrase that I used in my testimony is represented by the by the program itself, by the Clean Fuels Marketplace itself, referring to the purchase and generation of credits that are bought and sold in the Clean Fuels Marketplace. That would be the balanced marketplace reference. That's where it comes from.
So is it limited to the way the statute reads or some other legal representation?
For the market, it is it's simply a reference to the forum in which an entity buys or sells the credit. In a marketplace, there's no definition of marketplace in the rule. It's just a description of what the program does.
And is there any definition in the statute?
Of the term marketplace?
And particularly balanced market-based approach?
Oh, no, that would be my reference to the statute and the program that is presented today.
Okay. And I'm assuming you're going to answer yes to this, but would you agree that Secretary James Kenney is your boss?
Please repeat. Yes. Mr. Weatherby, we're having a little trouble hearing you. Would you repeat your question and speak up?
Okay. Is this better? I'll speak up a little bit.
Yes, it is.
Okay. Thank you. Would you agree that Secretary James Kenney is your boss?
Objection, Madam Hearing Officer. This is irrelevant to this hearing.
Okay, I guess I don't find it objectionable. Director Miano?
I can say that Secretary Kenney is my boss, yes.
Thank you. So the Clean Transportation Fuel Standard Program in subsection B states that the Secretary shall convene an advisory committee composed of stakeholders, and it goes on. You stated in your opening testimony, I believe, that the Secretary convened a Clean Fuels Advisory Committee with a diverse set of represented parties. Do you know how the Secretary went about determining whom he would convene as an advisory committee?
He accepted, and we've really facilitated that as a department. A lot of times the statutes
name the secretary, and we as the department will carry out that directive. So we developed an application process, and we had different entities and individuals apply. And then Secretary Kenny selected from the applicants those entities that met the directive of the statute, and we convened the Clean Fuel Advisory Committee shortly thereafter. We provided notice to everyone that they were selected.
And did the secretary participate in the run out of that selection, of how you put it together, the group that you reached out to, or groups that you reached out to?
Oh, it was published on our website, and we sent out a press release and other materials on our web presence and elsewhere, notifying the public that the advisory committee application process, acceptance process was open, or application process was open. So nobody was precluded from applying. We were very broad about our outreach on that front.
Okay, thank you. The next few questions have to do with your testimony regarding the state strategy on its economic goals as it relates to the proposed rule. And you indicated through your answers to earlier questions from other parties that you are well versed in the subject of the state of New Mexico's strategy on its economic goals and interactions with NM, the New Mexico Economic Development Department, on businesses that may have an interest in locating in New Mexico. In the development of this rule, how do you, let me rephrase this. Who takes the lead on the recruitment of companies to locate advanced energy entities that might take advantage of this? Is it your agency, or is it the Economic Development Agency?
Well, we have companies reaching out all the time. And so it'll be whoever the company determines to reach out to first. Sometimes they reach out to our agency first because we're the agency that is standing up the Clean Transportation Fuels program. But then if we are in a conversation with that company and they're looking for example, location options, I will refer them over to the Economic Development Department, because they have special teams that help companies locate where they might want to develop their, their working space or their project or something like that. So it really depends on what the company wants.
Okay. And did the Economic Development Department play a significant role with your team in drafting the proposed rule?
No.
Were they participants at all, or can you give some level of involvement that they may have had?
Mostly I would explain to them where we were in the rulemaking process, and they would communicate that to companies that would have reached out to them, because they were also getting and continue to get inquiries about when the program is going to get stood up. And so it really depends. Most of the time it was me or one of my team members, educating the Economic Development Department on where we were in the rulemaking process, and if a company could get what kind of credit on what kind of technology. And a lot of that, of course, determines on the outcome of this hearing. So we could provide information to them generally about how the rules play out, but a lot of the companies are keeping their information close to the vest until the rules are finalized.
Okay. And I think one or maybe two more questions. I believe, let me just check where this quote is from. I believe it was in your testimony, but there was a reference that the state is currently among the most 10 fiscally vulnerable states. Can you explain what is meant by most fiscally vulnerable?
Yes, that is a reference to a statement in the Economic Development Department's 2025 State Plan Update. It's my Exhibit 6. And there are many factors that go into a statement like that that are best described in that report. But one of the considerations is that our state economy is not diversified. And if we have a more diversified economy, i.e., an economy that doesn't depend on one industry, but depends on many different kinds of industries, that the state can economically be more stable and weather different kinds of economic up and downturns.
And in your understanding of this, what do you mean by, or what type of industries are you referring to as the state being most heavily reliant on?
Well, I think the Economic Development Department report expressly says that the boom and bust cycle of the oil and gas industry and our state's heavy reliance on that, although we receive a lot of benefits during the boom times, there's always the concern that there's a finite resource that is generating this kind of wealth, and that by diversifying into different areas like advanced manufacturing and climate technology, that we will have the stability over time to make sure that if there are economic up and down turns or boom and bust cycles, New Mexico won't be as affected as it has been in the past.
So, Madam Hearing Officer, do I have a few more minutes? I would like to pursue this a little bit if I do.
Yes, you do.
Okay. So, you mentioned that you have a significant amount of experience in a high-level way or high-view way of the interaction of your agency and the economic needs of the state and your interactions with the Economic Development Department. But where do you get your information as to what industries are actually the most prevalent in terms of employment in the state, which is a significant component to an economy?
Well, there's quite a few reports we have in addition to the Economic Development Department. The state also has its Development of Workforce Solutions, and I'm not sure if there are other agencies that collect employment numbers, but those are a couple of them.
Are you aware of the industry that has the most growth projected for the state of New Mexico?
As you mean as of 2025?
Over the next 10 years, between now and between now and 33, say, the next 5 years.
I'm not sure what that projection is.
No, it was released today. It's consistent.
Madam Hearing
It's been
Officer.
consistently.
Hold on, Mr. Weatherby. If you're going to be testifying, I have to take your statement later.
No, it's not a testimony. I want to point out and ask, I will rephrase the question.
All right.
My apologies. So according to the Department of Workforce Solutions recent release, and it's been around actually the same
Madam Hearing
information.
Officer.
He has a question.
I'm asking, I'm trying to, I'm not an attorney, so I guess I'm trying to lay the foundation for the question. There is information.
Yes, Mr. Weatherby, ask her to assume that what you're about to say is true and then ask your question.
Okay, okay. Assuming that what I'm going to say is true, the Department of Workforce Solutions has consistently reported that the fastest and, or I shouldn't say the fastest, the area of industry for job creation that's going to grow the most over the next 10 years, and this has gone back for the previous 5 years, is in the health care industry. And yet much of our policy here is being developed based upon the assumption in your testimony and in what I've seen submitted so far is the interest to diversify the economy as it relates to energy issues or energy companies. And I'm trying to understand why, or if people really understand that there are other things that are impacting, and if you understand that there are other areas of the economy that are actually driving New Mexico's economy. Because the essence of the testimony here is that we need to do this for New Mexico because the economy isn't diverse enough. So do you take into consideration the other information relative to job creation and its impact on the economy as much as you do, say, the oil and gas industry?
Well, I would say yes. And one of the other pieces of information in the Economic Development Department report in my testimony, it actually might cite to healthcare workers, but really state workers. We have a robust state workforce that comprises a lot of the economy too. So that's another consideration. Again, this is not a proposal that's going to solve all of the state's problems and all of its goals in this economic development report that's in my testimony, but it will certainly make a difference.
Would you say that it is a primary reason for advancing this rule?
There are 3 reasons for this rule. 1 is economic development, 2 is the greenhouse gas emissions, and then 3 is the environmental benefits that we project will occur with the rule adopted, and not necessarily any particular order, but those are the 3 primary reasons why I think, honestly, the legislature adopted this law and has directed us to create this program.
Okay, and the final question is, do you believe that there is, or can you expound a little bit on whether you feel there is any tension between the goal of diversifying the economy by fostering the growth, as it states, of a variety of sectors and reduce revenue volatility with the mission of NMED to protect and restore the environment and to foster a healthy and prosperous state?
I would say that one, and this is also in my testimony, I've had some amazing conversations about with companies about technologies that have no emissions, have no byproducts. The Environment Department has an entire bureau of underground storage tank regulators. I'd love, not to be able, I'd love to say that we have, you know, uh, environment department that is less and less needed over time because our fuels get cleaner and cleaner over time, and we don't have to address spills and these kinds of incidents that we make sure occur and are conducted at the environment department. So I'm actually quite optimistic about these new technologies and new fuels coming in, and I do think the ones I have seen and the companies I've talked to, given their huge decreases in pollutants, some of them, I think that's very much in line with the mission of the department.
Okay, thank you very much, and thank you, Madam Hearing Officer and members of the board. I'll try to clean up how I ask questions in the future. Thank you again.
All right, thank you, Mr. Weatherby. I think before we turn to the board for their questions, we'll take a 15-minute break. Please come back at 2:52 or thereabouts.
But and I can't recall off the top of my head if they participated in some of our meetings or our outreach, but they do have fueling stations and the fueling terminals rather that would be affected by the rule, and so they will certainly continue to be a big part of our outreach.
All right, Member Garcia, do you have questions?
Yes, thank you. Director Miano, you mentioned that you all have consulted with other states that already have these programs to try to learn from their mistakes or things that they wish they had done differently, et cetera. I understand that the incentivization of biogas producers, such as CAFOs, concentrated animal feeding operations, has been controversial in California. And there were comments today about potential problems with increasing that industry in New Mexico. Is there anything in the current proposed rule that would help or anything the Environment Department could do that would help mitigate potential problems with that industry?
Thank you, Madam Chair, Member Garcia. That is a great question. And one of the scenarios that is occurring in California is the way that they operate dairies is very different than the way that we operate dairies in New Mexico based on our climate. So in California, you have wet dairy management that results in much more methane and methane emissions as a result of the CAFOs in that state. In New Mexico, and we learned a lot about this going into the legislation and working with the legislation, we have dry dairy management here in our state, which is different from California. And part of it's our climate, part of it is our Environment Department regulations for, I'm not well versed on this, but the dairy rule that was passed some time ago, it really forces a different kind of management here in New Mexico than other dairies. So there has been some work to figure out how New Mexico dairies would be able to benefit from a program given dry dairy management with anaerobic digesters. And there have been some, I think there's one down in Dexter, New Mexico, that captures methane. But from our analysis, it's still, because of our dry dairy management, will still be a very small piece of how credits are generated in our New Mexico market. And so it's almost a self-mitigating situation here in our state versus in California. So just the way that we have dairy management here mitigates itself because we don't have wet dairy management.
Okay, thank you very much.
All right. We're hearing some extraneous noise from the AV booth up there. Please lower your voices. I don't think they can hear me. Member Honker, do you have a question of Director Miano?
Yes, a few questions, basic questions on the rule. And the first one is kind of a follow-up to Member Ely's question. Will the requirements of this rule apply everywhere in the state? Are there any lands or areas in the state that would not be subject to this rule?
Thank you, Madam Chair, Member Honker. That's a great question. And I realize that because I'm first and we haven't gotten into the detail of the rule, you're at a disadvantage. And I promise you that you will have the in-depth discussion in our next panel about how the rule works. So I'll give you a general answer, Member Honker, which is this rule generally applies on state lands. And that's true of the Albuquerque-Bernalillo jurisdiction as well. And so that is really where we're looking at. We don't have jurisdiction generally over tribal lands, so that would be an exception. So to answer your question, state lands.
What about federal lands?
Oh, good question also. It would be on and it's very fact specific, so maybe what I should do is wait until my colleagues are able to talk to you about how the rule works, and I promise we'll get into some details there.
Okay, thanks. Second question, did the legislature provide any additional resources or authorize any additional FTE to the department to implement this rule?
Madam Chair, Member Honker. another great question. They gave us the authority in the law to obtain fees for running and enforcing the program. And so we right now have received general fund in order to come before you today and pay for our staff here and get the material and the proposal before you. And then ultimately, we will be weaning off general fund and be a enterprise type fee-based program that should run itself with the fees that we obtain from those entities that are participating in the market.
Okay, thanks. Last question. You mentioned you had 14 existing positions. You were hoping to, or expecting to hire 3 more. Has the department done a longer range resource plan for the resources required to implement this over the years? And has the department identified any areas of expertise that you don't currently have that you'll need to implement the program?
Madam Chair, Member Honker, we have thought about this greatly. And in our team, really a very particular expertise is a life cycle fuel analyst who really is an expert in that modeling that we talked about earlier about all of the different greenhouse gases that go into different parts of the supply chain. That life cycle fuel analysis, we've been to all different kinds of states and talked to different folks, and they are a needle in a haystack. And I'm very proud to present that we currently just hired our fuel life cycle analyst here at the department who has just started and is getting up to speed. But that particular expertise is really important. So that's somebody that an employee position that we created and brought on for this program specifically. And a lot of our increase will be around, honestly, the credit generation with the alternative fuel pathways that you'll hear about in later testimony, and analyzing companies and applications coming in to receive these kinds of credits. And so those are areas that we hope to expand to make sure that we have enough folks for the applications. But in the meantime, as we create the positions and go through the state personnel office process, we can lean on consultants in the meantime to help us out to make sure that we're never without the expertise needed to run the program.
Okay, thanks. Thanks, Director.
Thank you. Vice Chair Trujillo, do you have questions?
I do not at this time.
All right. Member Bitzer online, do you have questions of the director?
I do not. Thank you.
All right. Thank you, Madam Chair.
Thank you, Madam Hearing Officer, and thank you for your testimony today and all the work the department has done to get to today. I have a couple of comments, and I'll go back to the Clean Transportation Advisory Committee. I just wanted to hear more about that committee. For example, was there a limit to how many people could be on the committee? I understood from your question and answer there was an application process. Maybe just hear about more about if it was inclusive. It sounded like it was inclusive, but if ultimately, what were the goals in terms of, if you could talk more about the comprehensive nature of that committee, and then, like I said, if there was if it was to limit on number, if there was goals about different sectors and different community representatives, stuff like that. Thank you.
Thank you, Chair Sweeney, members of the board. Our mindset going into the clean fuel advisory process is that we need a lot of listening sessions from a lot of different sectors, a lot of different groups, a lot of different individuals. And fortunately, that directive was reflected in the statute itself. Not a lot of statutes have that directive. So we put together the application process and fortunately received a wave of applications. We did not have a maximum number of people, but tried to keep it so it wouldn't get too unruly in an auditorium style with too many people. So we wanted to make sure that we really had input from industry and community advocates and make sure that we're reflecting on what the statute wants us to provide. We even had folks participate who were companies interested in obtaining clean fuels for their business goals that couldn't get the clean fuels that they wanted in New Mexico as part of their decarbonization process. So they participated and told us, this is what we're looking for so that we can, there's some things, for example, electricity can only go so far in order to help with what other kind of options are out there. So I thought that was really interesting. We also had, folks from the entities that calculate credits in the credit market and verify those credits. There are a lot of experts that have developed professions out in the other jurisdictions that have this program that kind of know how it works. And so they want to make sure that they're helping clients and understand the rule. We had folks that were interested in making sure that there was enough consideration for more holistic transportation policy and not just the narrow program, but how it fits into the larger state goal. And of course, we had a lot of companies, both petroleum companies and non-petroleum companies, interested because they know they will be generating deficits or creating credits. And they wanted to provide us input on their observations working in other markets about what the Environment Department should consider as we sat down and put pen to paper for our rules. And so we amassed a biblical amount of paper in order to capture these kinds of this kind of input and these kinds of recommendations and provide to the advisory committee a little bit where we were at in our rulemaking or in our the place we were at as far as our rulemaking process, and so that we could communicate to the Clean Fuel Advisory members where we were so that everybody started on the same playing field about understanding where the department was as it was digesting all of these recommendations.
Thank you for that response. I guess maybe that kind of segues into my next question is in your written testimony, you shared with us that NMED learned from these jurisdictions how the CTFP market can't be established and completed without a single rulemaking. There's also different new phrasing of words that have come up, like novel carbon intensities, and I think another one was balanced market-based approach. And so with that, and I think what you shared with the board earlier, there has been a lot of research and learning in order to come here today. So I was just wondering, one particular aspect of your written testimony is about learning that more frequent and regular rulemaking would be needed in order for this program to work. Can you expand upon what's regular and frequent? And because it would be coming before the board, if you will. Thank you.
Thank you, Chair Suena. Yes, I know it's been a lot, and I know it's you, Madam Chair, and the rest of the member of the board have been amazing in all of the work that we have brought to you over even since I've been here. So for the regular and frequent rulemakings, what we've learned from other states, and I'll take our GREET model as an example, the GREET model. There's always science developments and new calculations and better data and more accurate reporting methods. And it's like science, it's constantly evolving, and there's always better and more as we frankly get more knowledge as to how our planet works and how these programs work. And so one example I'll give is the discussion that constantly happens over these GREET values and which GREET values and which GREET model, and do we even use the GREET model because there are other models and we don't know because this model says this way and this other model says this other way. And with the model that we've chosen as the department, when we adopt the rule, it will freeze that model in time in a way to provide that kind of certainty. There'll always be the ability under the rule for entities to apply, as you'll hear from my colleagues, on fuel pathways and novel fuel pathways or alternative fuel pathways. But, you know, we anticipate updating the science around that GREET model over time. In the other states, one of the big areas of controversy is the indirect land use change value and what that means and how it's calculated and what goes into calculating it and how we think about it. And this is, you know, Bureau Chief Claudia Borchert and I went to Sacramento and met like the person in the country working on the indirect land use change, and he had a pile of paper. You know, it's very everybody's trying to do the right thing to make the best decisions on the best available science, and that's one that we anticipate having to update going forward, as far as we want to make sure that we're using, maybe we update the ILUC value in a different time in the future when we have better data, or something like that would be an example of an issue that would need a rulemaking. I think in the other states it's been every 2 or 3 years. And I told my team to cover their ears, but we will likely be starting another rulemaking at some point. But after this rulemaking process, we'll move right into developing guidance for a lot of the processes that we'll have to implement in the department to provide everybody with the administrative direction that they would need for applications and that sort of thing. So we'll finish the rulemaking, make the, you know, draft all of the guidance documents, and we have, you know, our database that will be running the program on track for our implementation deadline. And so hopefully it won't be next year, but definitely in the next 2 or 3 years to make sure that we are making the same, like we're looking at the market very closely and making sure that we're keeping it in line and healthy and those sorts of pieces. So I hope that answers your question.
Yes, and actually, I don't know if you have a question. Oh, Vice Chair has a question, and then I'll go.
I'm curious, as you draft those guidance documents and you move
in the future for other rulemaking processes, are you going to keep the advisory group going? It will be there. Will you restart it every time, or is it something that just gonna kind of roll through?
Madam Chair, Madam Vice Chair, that's a great question. We will be the initial one, the inaugural one, helped us get to where we are. And then we will be convening a new one at some point in the future, which will have a new application process, but still meet all those statutory criteria to make sure that we're continuing to keep everybody at the table and make sure that we're not being exclusive, but more inclusive. And that is the vision for the next phase.
Thank you for that. So maybe to that takes me to my next question. I understand the regular and frequent rulemaking process now. Thank you for that response as well. So back to, I think you mentioned it in the response to that question about the carbon and total carbon intensity baseline for fuel transportation fuels from 2018 as the baseline. Can you just maybe elaborate a little bit more on why NMED relied upon that baseline from a policy, I guess, perspective? I think you mentioned the statute, because I understand that there'll be, from the written testimony, that your colleagues will elaborate on some of the more technical aspects. But in doing that too, I think, am I correct in saying that if that were to change in the future, that could be revisited in future rulemakings if there's some additional or changes in how things are modeled, I guess. Thanks.
Madam Chair, it's a good question. So there aren't many black and white directives in our statute that we're following. It has these general guidelines about how to fulfill certain tenets of the program. The one non-negotiable was that statutory carbon intensity reduction that used the 2018 baseline. So that's where we lifted our analysis from. And so in the future, it wouldn't be through rulemaking because it's in statute, but the legislature could come back and adjust that baseline year based on a legislative change, would be how that could occur.
Thank you for clarifying that. Appreciate that. And you have a couple more questions. You were talking about the way the program would work in the future in terms of funding department staff and resources. Did other states structure similar programs like that in their states in terms of, were they general fund or legislative funding to staff up and to start this initial, and then the fees would take over as the program progressed?
That's a great question, Madam Chair. I recall one of the states, I forget which, was all general fund. So they didn't have the fee mechanism. And my colleagues will be able to speak more about the individual states and their revenues for purposes of running the program.
Okay, thank you.
I will make a note.
All right. Ms. Sona, do you have redirect of Director Miano?
Thank you, Madam Hearing Officer. I know we just took a break, but our next panel is going to have PowerPoint presentations. I'm wondering if we might take a brief break to get all of those set up so that we can smoothly flow from Director Miano into their testimony.
Certainly. It's 3:20. Is 3:30 okay?
Yes, I think that'll be sufficient.
All right, 3:30. All righty. We are back after a short break. Ms. Sona, do I take it you do not have redirect of Director Miano?
Yes, Madam Hearing Officer, we do not have any redirect for Director Miano.
Great. So I'm going to ask the witnesses for the next panel to state and spell their first and last name in turn. Let's start here.
My name is Angela Rasso, Angela Rasso.
Do you swear or affirm to tell the truth?
Yes.
Thank you, Dr. Rasso. Ms. Borchert?
Claudia Borchert, Claudia, Borchert, Borchert.
Do you swear or affirm to tell the truth?
I do.
Thank you, sir.
Colt Vaughn. Wow, that's loud. I apologize. Spelled Koltvaughan.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead, Ms. Sona.
Good afternoon, Board. NMED is now bringing to you its first panel of the technical experts to talk to you about the intricacies of this rulemaking. I will share with you that this panel is intended to include 4 witnesses. We are moving a little faster, actually, than we anticipated, and one of our witnesses is not in town yet. And so I anticipate that we'll get through the oral presentation of these 3 folks, and then would like to reserve the time for our 4th witness to get us started right there in the morning. And I believe that will also help round it out for you and refresh you on what you heard today to help get us through some of the very technical complexities of this. So thank you. Our first witness on this panel is going to be Mr. Vaughn. Mr. Vaughn, can you please share with us where you're employed?
The New Mexico Environment Department.
And how long have you worked for NMED?
Since September of 2023.
What roles have you held at NMED?
Over the last 2 years with the department's Climate Change Bureau, I've held the role Rulemaking and Strategic Initiative Specialist.
And in that role, can you share with the board and the parties what your job duties entail?
Yes. Generally, my responsibilities at the Climate Change Bureau include supporting the development and implementation of state climate policy, projects, and programs, conducting NMED and Climate Change Bureau communications, and evaluating and improving programs to fulfill the mission of NMED and the Climate Change Bureau. Additionally, throughout my work with the Climate Change Bureau, I have concentrated heavily on developing policies to reduce emissions from transportation. However, most significantly, I have served as the overall project manager for the CTFP rulemaking effort for the past 17 months, bringing both broad and specialized experience to this effort.
Thank you, Mr. Vaughn. Before you started with NMED, can you briefly share what your work experiences included?
Well, I have held several environmental and scientific roles since February of 2018. However, most recently, I worked as an environmental health and safety specialist for the University of New Mexico, or UNM. That job entailed improving water quality in the Middle Rio Grande by ensuring compliance with the Clean Water Act, ensuring safe drinking water for UNM's consumers under the Safe Drinking Water Act, protecting UNM's primary source of drinking and irrigation water, and co-administering UNM's Title V permit to ensure Clean Air Act compliance.
Turning back to the rulemaking, is NMED Exhibit 35 your resume?
Yes.
Is NMED Exhibit 34 a written narrative of your testimony?
Yes.
Was this exhibit refiled for clarification to ensure it included the Table 1 in Appendix B?
Yes, that is correct.
Do you have any other corrections that you'd like to make to your written testimony today?
No.
Do you adopt NMED Exhibit 34 as your testimony today?
Yes.
With that, have you prepared a written oral summary to share with the board today?
I have.
Do you also have a PowerPoint presentation?
I do. It is only one slide, and I will leave it up throughout my testimony. And I would draw the board's attention to it if you are able to. I would also draw the board's attention to it if you are able to review it through the WebEx platform.
Thank you, Mr. Vaughn. If you're comfortable with your position in the microphone, please go ahead and read your summary of your testimony for the board.
Thank you. Madam Hearing Officer, Chair Sweeney, and members of the board, good afternoon. First, I'm going to have to move this. First, I would like to thank you for your time and service to the state of New Mexico. I appreciate the opportunity to testify in support of the Clean Transportation Fuel Program. Before we dive in, let me clarify a few acronyms and key terms. In my testimony, I may use CCB to represent the Climate Change Bureau, NMED or the department for referring to the New Mexico Environment Department, and CTFP for the Clean Transportation Fuel Program. I will also use the key terms petition for the department's petition filed on May 16th, 2025, petition proposed new rule for the rule proposed in that petition, and revised proposed new rule for the modified version filed on September 2nd of 2025. My written testimony goes into great detail on the engagement that the department performed. This oral summary will be rather brief, so I do absolutely encourage and welcome questions about NMED's engagement. The purpose of my testimony today is to first describe the department's comprehensive and robust process for outreach and engagement. Second, to walk you through our rulemaking history in this matter. And third, to highlight a few additional elements of the proposed rule that are not discussed in the testimony of the other department witnesses. With that, I would like to provide some practical background information and then summarize the department's engagement for this rulemaking effort. The transportation sector is a difficult one for reducing greenhouse gas emissions in New Mexico, mainly because we're dealing with mobile sources here. The legislature and the governor recognized this reality when they prompted the department to develop a new rule to address this challenge and gave EIB a deadline by which to act so that we as a state can continue chipping away at this challenging sector. We took that responsibility seriously. For this rulemaking, as I will demonstrate, I believe the department has exceeded the engagement expectations of both the public and the board. Since April 2024, NMED has engaged early and often, listened deeply, and overturned every stone we could think of, adjusting the program to account for input from New Mexicans and businesses operating in New Mexico. Now, if you take nothing else from my written or oral testimony today, please remember these three things. First, the department provided all legally required notices for this rulemaking hearing. Second, the department went well above what was required, as my written testimony discusses in great detail, and as my one PowerPoint slide summarizes. Third, all of the feedback we received at every stage genuinely shaped the rule before you and informed the department's decisions as it was drafted, resulting in a tailor-made, robust program design for New Mexico. Let me walk you through how we accomplished this. Our rulemaking story begins in April 2024, just a month after the Environmental Improvement Act was amended. The statute required us to convene an advisory committee, but we didn't want a committee that would just preach to the choir. Michelle talked about that a little bit in her testimony as well. Instead, we needed to understand the technical hurdles and the real-world impacts from day one. So we intentionally brought together a diverse group of 31 experts, including people whose bottom lines would be directly affected by the program and who we knew would not agree on a path forward. Among others, we had representatives from the fossil fuel industry, clean fuel producers, environmental groups, and utilities. We did not expect consensus. Our goal was the opposite. We wanted to hear every conflicting perspective and technical concern before we wrote a single word of the rule. Over the course of 4 meetings, we prompted them with specific questions to facilitate dialogue. Our role was to guide the conversation and ensure we captured the detailed input we needed. The result was the Advisory Committee Technical Report. It's not a consensus document. Rather, it is a compilation of the varied and competing expert opinions that we sought. Ultimately, it was the perfect foundation for our work. With a technical report in hand, the hard work began. We followed a deliberate 5-step process to build this rule from the ground up. The first step, metaphorically, we hit the road. The first thing we did was take the ideas and concerns from our advisory committee to the states that already have these programs, like Washington and California. This was essential. We needed to understand what we were being told in real-world context. We asked them things like, how would these recommendations actually impact your program? What worked and what hasn't, and so on and so forth. The reality is that the staff from the state of Washington's Department of Ecology have provided the most vigorous, highly technical, on-the-job training to NMED staff that we could have possibly received. This training focused on initial program design and preparations for implementation. Additionally, the Washington Department of Ecology, specifically Abby Brown, has submitted a comment in this matter confirming that this engagement as I have described it. Armed with the lessons learned from other states, we then met extensively with the industry operating right here in New Mexico. We held numerous technical meetings with groups like the New Mexico Oil and Gas Association and American Petroleum Institute, utilities, low carbon fuel coalitions, and individual companies like HF Sinclair to discuss how these concepts would apply specifically to their operations. Next, we released a public quote-unquote discussion draft rule in December of 2024. This was our first attempt to synthesize everything that we had learned in a coherent proposal. It brought a whole new round of engagement, and it generated 531 pages of detailed public input. This input was monumental in refining the program's design. Based on that feedback, we developed the petition proposed new rule, and even after filing it, we continued to meet with interested parties and accept additional comments, which led to the revised proposed new rule you have today. Finally, there comes a point where you must put a pause on taking input so that you can actually establish a rule. We had listened for over a year, held more than 160 meetings, and analyzed thousands of pages of input. In order to meet the statute's intent, we decided to move forward with a proposal based on that exhaustive record. This entire process was designed to ensure the revised proposed new rule was technically feasible, economically reasonable, protective of environmental health, and built for New Mexico. Our outreach didn't stop there. We also held public meetings, issued news releases, and sent numerous listserv emails to keep people informed. Throughout this process, we also conducted outreach to all 24 of New Mexico's tribes, nations, and pueblos. We provided presentations, sent unique letters, and made ourselves available to discuss how the program could operate and benefit tribal governments. While no tribe chose to participate at this stage, we are committed to continuing this dialogue. And our work isn't done. This rule is designed to be dynamic. The program includes the reconvening of an advisory committee to review the rule's performance and recommend improvements periodically. As demonstrated throughout this rulemaking process, we are committed to continuing outreach and evolving this program to meet the needs of New Mexico now and in the future. Madam Hearing Officer, Chair Sweeney, and members of the board, in summary, the department conducted a thorough and responsive rulemaking process that went far beyond the minimum requirements. We deliberately sought out this agreement to understand every angle of every issue. We reality tested ideas in other states, and the final product is a proposal that accounts for and is genuinely responsive to public input. We know we can't perfectly anticipate every challenge we will face, but the revised proposed new rule reflects a laborious and meticulous effort to balance stakeholder concerns, statutory mandates, and scientific realities. Likewise, the department is committed to revising the final rule regularly to improve it, just like every other state. And despite these challenges, the revised proposed new rule is in the public interest and protective of environmental and public health. And my colleagues will further demonstrate that it is technically feasible and economically reasonable. Therefore, I respectfully urge the Environmental Improvement Board to adopt this proposal. Thank you for your time, and I encourage and look forward to your questions. Thank you.
Thank you, Mr. Vaughn. Madam Hearing Officer, if I may move on to the next witness in the panel.
Please do that.
Thank you. Ms. Borchert, can you share with us where you are employed?
I'm employed at NMED, at the New Mexico Environment Department. How's that sound? Okay. All right.
And how long have you worked for the Environment Department?
I have worked there nearly 5 years. I started in November of 2020.
And in that time, what roles have you held with NMED?
My first job there for the first 2 years was as the Climate Change Policy Coordinator. And when the Climate Change Bureau was set up 2 years later, I became the Bureau Chief of the Climate Change Bureau.
As the Bureau Chief for the Climate Change Bureau, can you share with us a brief summary of your job duties?
Yes, the Climate Change Bureau basically has 3 responsibilities. The development and the implementation of this program is one. The other program that we're implementing is the new motor vehicle emission standards, and Dr. Rosso is in charge of the implementation of that program. And then more to high level, the Bureau is responsible for meeting the greenhouse gas reduction targets that our governor set out in an executive order to reduce our emissions by 45% by 2030 and 50% entirely by 2050 from a 2005 baseline. So our group is responsible for determining all the different policies that we need in order to achieve those greenhouse gas emission reductions.
Thank you. Before you started at NMED, can you share some of your most recent work experience?
Yes, I was the sustainability manager for Santa Fe County for 3 years. And for the 3 years before that, I was Santa Fe County's water and wastewater utility director. And before that, I worked for the city of Santa Fe for 10 years, managing their water resources.
Can you briefly describe for us your educational qualifications?
Yes, I have a bachelor's from Amherst College in geology, And then I have a master's from UNM in hydrogeology.
Is NMED Exhibit 64 a copy of your resume?
Yes.
Is NMED Exhibit 63 your written narrative of your testimony?
Yes.
Do you have any corrections to that testimony that was pre-filed?
I do. I want to clarify that on page 22 of my written testimony, I have this, the phrase that is, the CTFP is funded by program fees collected by program participants, and the by in that phrase needs to be corrected to from, so that it reads, the CTFP is funded by program fees collected from program participants.
Thank you, Ms. Borchert. With that correction, do you adopt NMED Exhibit 63 as your testimony today?
I do.
Have you prepared a summary of that testimony to share?
Yes, I have.
And do you have a PowerPoint presentation to accompany your oral summary?
Yes, I do.
Okay. Please go ahead and get situated and share with us your summary and presentation.
As my colleagues have testified, the proposed CTFP is a landmark program for New Mexico that will position New Mexico to become home for more clean energy jobs and investments while steadfastly securing environmental and health protections that New Mexicans expect and deserve. Today, I will describe how a clean transportation fuel program in New Mexico would work. Then I will provide specifics on the revised rule, NMED Exhibit 2, as filed in NMED's NOI on September 2nd. I will also provide context for some of the changes NMED made between the proposed and the revised rule. To see a more detailed list of the clarifying and programmatic changes between the two versions, please look at pages 25 through 29 in my written testimony. As Director Miano described in her testimony, the CTFP has three foundational parts that work together to achieve program success. First, the CTFP sets annual carbon intensity, or CI, standards in grams of carbon dioxide equivalents per megajoule for all transportation fuel consumed in New Mexico. This metric can also be thought of as the carbon footprint normalized to an output of energy. The standards are represented by the two curves in this graph. The black line for gasoline and gasoline substitutes, and the dashed gray line for diesel and diesel substitutes. Over time, as represented by years along the x-axis, the benchmarks decrease, along the way hitting the two statutory targets in 2030 and 2040. For every compliance year, fuels that are greater than the CI standards generate deficits, while fuels that are less than the standards generate credits. This slide presents the numerical values of the program standards that resulted in the curve on the previous slide. As directed by statute, the starting point for the compliance is the 2018 baseline. And it's also the actual fuel mix consumed in New Mexico in 2018, which for gasoline, for example, included 9.7% ethanol. The annual standards are generated by applying the percent reductions from the 2018 baseline to reach the 20% by 2030 and 30% by 2040 mandates. You can see the percent reductions in the furthest right column there in this slide. Our baseline values changed between the petition rule and the revised rule as the NMED team and our experts honed the methodology to calculate the baselines. These CI standards are in Table 1 and 2 of Section 701. Second, the program determines a carbon intensity value for all transportation fuels consumed in New Mexico. As described by other members of the NMED team and on this slide, the carbon footprint of each fuel must account for the greenhouse gas emissions associated with producing, transporting, and consuming of that fuel as determined through a life cycle greenhouse gas assessment. This slide shows the CI value for two different fuels, gasoline and ethanol, and illustrates the components that are calculated to determine their individual carbon intensity. The final component of the program is the requirement that parties with deficits demonstrate compliance annually by bringing their deficits into alignment with the applicable CI standard. Through competitive private market transactions, the CTFP allows the deficit generators to seek the most competitive way to reach compliance, which could be through diversifying their fuel portfolio or by securing program credits. Through price signals, the market influences the mix of clean fuels that combine reach the program's carbon intensity standards. The scale in this illustration tips to the side of clean fuels, showing that over time, the goal of the program is to increase the amount of clean fuels consumed in the state. In fact, in all existing programs, credit generation has outpaced deficit generation, a testament to the ingenuity of the clean fuel industry. During the development of Part 92, our team meticulously embedded the provisions in the CTFP in the program statute in Chapter 1 of the Environmental Improvement Act. The statute is included as NMED Reference 3, Sections A through F. And page 23 of my testimony gives a more comprehensive list of the statutory requirements. And I'd like to highlight those here that our team kept front of mind. And I'll list them as well as the fact that they're on the slide. Achieving 2030 and 2040 carbon intensity targets through an annual reduction schedule. Verifying compliance obligations. Ensuring market stability. Protecting consumers and containing costs. Remaining technology neutral. Requiring utility revenue reinvestment. Aligning with low carbon fuel programs in other jurisdictions, maintaining program transparency, and evaluating the program regularly. The team adopted other North Star principles that we consider vital for program success, tailoring the rules to New Mexico, building a strong team of in-house expertise, and relying on world-class experts as necessary. We've talked about our fantastic team here. Relying on the best available peer-reviewed science, specifically in life cycle emissions appropriate for transportation fuels consumed in New Mexico. The program's choices are often conservative in recognition that meeting the CI reduction is paramount. NMED's scientific choices also underline our commitment to provide certainty and stability to the fuel providers so they can make decisions knowing the lay of the land without it changing from year to year. This approach still gives NMED the option to reconsider new scientific information as it becomes available and to systematically update Part 92 following the process. Part 92, that's a shorthand for the rule, Part 92. Following the processes and notice as we did in the development of this rule. Finally, we consider how this program will reduce greenhouse gas emissions. Currently, the revised rule, I have a few pictures sprinkled in here so that you're not distracted by the slide when I'm actually not speaking to the content of the slide. Currently, the revised rule includes an effective date of February 1, 2026, which would have been feasible if the board concluded this hearing in mid-October. We know that's not the case. NMBD understands that the proposed rule, if approved, will need a revised effective date, and we suggest working out a new effective date after the conclusion of this 2-week hearing, recognizing that the sooner the program is implemented, the sooner New Mexicans reap the economic and health benefits of the program, and the sooner the tangible reductions of greenhouse gases begins. Now let's dive into the proposed rule. With a 92-page rule and a 30-minute time limit for my oral summary, I will obviously not be able to describe the majority of Part 92. My presentation focuses on those sections that might provide the board with a better understanding of the rule's contents. I also highlight some of the revisions NMED proposes between the petition rule and the revised rule. For insight into the terms that are ubiquitous to the rule, I recommend you look at pages 5 through 11 of my testimony, where I've grouped key vocabulary programmatically. Okay, let's start with the 100s, which describe applicability, exemptions, and the general program requirement. Section 101 notes that this rule applies to, and we'll be using this phrase a lot, transportation fuel that is produced in New Mexico, imported into New Mexico, or in the case of electricity and gaseous fuel, dispensed for use in New Mexico. Section 101 also designates which fuels are regulated and which are opt-in. Regulated fuels generally have a carbon intensity greater than the standards, while opt-in fuels have carbon intensities below the standards and are thus credit generating. To clarify which of the two annual carbon intensities apply, all low carbon fuels are divided into either gasoline substitutes or diesel substitutes, depending if they fuel light duty vehicles or medium and heavy duty vehicles. Section 102 exempts certain fuel uses and fuel types, including fuel used in aircraft, locomotives, and military tactical equipment. Dyed fuel used for off-road purposes is exempt until December 31, 2028. One confusion that we've heard about the rule is the regulatory burden Part 92 imposes on mom and pop type gas station owners. In reality, Section 102D clarifies that the rule targets fuel wholesalers upstream in the fuel supply chain and does not apply to gas and diesel retailers unless the retail business is also an importer. However, the program does offer a retail gas station a new revenue source. If a retailer, for example, installs a charging station that dispenses electricity, the retailer can sell the clean fuel credit based on the volume of electricity sold for additional income. Dr. Rosso's testimony provides information and instructive flow chart on fuel pathways and an alternative fuel pathways, the subject of the 200s, so I will skip. The sections within the 300s describe credit and deficit generation. Section 302 includes the circumstances under which fuel supply equipment, or FSE, another term we'll use a lot, can earn program credits based on its maximum operational capacity and its location. The program provides credits for FSE capacities because the team recognizes the need to support low carbon fueling infrastructure for clean fuels as a precursor to increasing the use of those clean fuels. FSC credits are technology neutral as they're available for the dispensing of any clean fuel, including 85% ethanol or E85, renewable compressed natural gas, hydrogen, and electricity. The FSC credit program in the rule is specifically designed to incentivize clean fuel infrastructure in less populated areas in New Mexico. Section 306 allows a party to seek project credits, demonstrating in their application the project demonstrably and verifiably reduces greenhouse gas emissions from transportation fuel consumed in New Mexico. Since the type and complexity of these greenhouse gas reducing projects vary widely and consume an unpredictable amount of program resources, the department proposes full recovery of administrative costs to review project applications on a case-by-case basis. Our team initially had misgivings about the complexity of reviewing project credits, while also recognizing the valuable role projects credits can play in reducing greenhouse gas emissions. Now the rule proposes to begin accepting applications for project credits July 1, 2026. Section 502 describes how the program determines program costs and allocates those. Oh, geez, I have just totally forgotten. Oh, no, here we are. Section 502 describes how the program determines program costs and allocates those costs to program participants. As shown in this slide, there are 4 fees: for registration, for the annual program, to apply for an alternative fuel pathway, and to apply for credit generating projects. The department bases the annual program fee on the projected annual administrative budget. After finalizing the budget through a public review process, each program participant is apportioned a part of the cost based on their gross credits and deficits as reported in the previous compliance period. The revised rule proposes to recoup 95% of the annual budget from deficit generating parties, based on the understanding from talking to staff at other programs that program staff will spend most of its time truing up gasoline and diesel transactions. As regulated entities and voluntary participating parties are required, all regulated entities and voluntarily participating parties are required to report their fuel use in the quarter after the transaction occurs. In the next quarter, after reviewing the reported information, the department will post credits and deficits in parties' accounts, at which time credit transactioning begins. All parties with deficits must demonstrate they have secured the necessary credits, in other words, demonstrate compliance, by April 30th. This slide shows the cadence of that system. And I also want to note that all of this occurs in the data management system, which you've heard Director Miano discuss, and we'll be hearing a lot more about that from Dr. Rosso. Section 508 helps assure the program does meet. Whoops. Okay. No more pictures. Section 508 helps assure that the program does indeed meet the carbon intensity reduction schedule by requiring third-party verification for specific components of the program. Third-party verification is required to confirm annual quarterly fuel reporting data, the validity of the information in an alternative fuel pathway application, the validity of the submittals in project credit applications, and the operational carbon intensity associated with each alternative fuel pathway. Section 601 allows the department to defer compliance with provisions of 92 due to emergency or forecasted conditions. An emergency deferral may be triggered by a force majeure type extreme and unusual circumstance that disrupts supply chains or has other unforeseen impacts. To determine if a deferral is necessary by a forecasted condition, the department is coordinating with the New Mexico Department of Transportation to complete an annual fuel supply forecast analysis. This analysis will project if anticipated credits from the next year's clean fuel consumption plus the banked credits will be sufficient to offset the anticipated fuel deficits from the upcoming year. Both of these deferral mechanisms contain the program's impact on consumer costs. Section 603 establishes a periodic review process for the department to evaluate the revised fuel rule and the program's performance. The review process includes convening an advisory committee, as has been discussed by Mr. Vaughn in his testimony. The review process allows the department, with valuable input from the advisory committee, to identify and design program adjustments that will lead to future proposed rule updates. Section 604 sets NMED's enforcement provisions and responsibilities and outlines the increasingly escalating interventions that the department will follow to ensure compliance with the program, starting with an investigation, then potentially leading to preliminary administrative enforcement action initiated by notice of noncompliance, and which may also identify the department's or the party's corrective actions. The department may also initiate an administrative enforcement action to cure the violation, obtain compliance, and assess a civil penalty for each violation. If warranted, NMED can then issue a compliance order with a civil penalty for each violation. The final recourse the department has with enforcement is taking civil action in the New Mexico District Court. The rule enforcement section, while the rule enforcement section does include a spectrum of enforcement options, the program expects to have an open door and problem-solving approach to resolve enforcement issues swiftly and appropriately, depending on the nature of the noncompliance. In summary, Part 92 presents a compendium of requirements that NMED and my team can successfully implement to bring transformational change to New Mexico from a comprehensive CTFP. Once implemented, a CTFP promises significant wins for our state. It brings more and cleaner fuel choices to fuel consumers, including more local and secure fuel alternatives. It secures clean energy jobs and increased investments in infrastructure, which by design focus on sparsely populated and low-income areas. It means cleaner air for all of us to breathe, especially those more vulnerable, our kids and elders. It positions New Mexico as a leader in the energy transition space, and it demonstrates our state's commitment to address the global climate crisis. Part 92 and the resulting CTFP program are structured to be technically practical and economically reasonable and provide significant health, economic, and environmental benefits. Just like the fall equinox today represents a balance between night and day, I am convinced that this proposed rule presents the right balance for New Mexico. On behalf of the department and all New Mexicans, I urge the members of the board to approve proposed Part 92, and I also urge you to do so as soon as practical. Lastly, I want to express our appreciation for the time you, the board, is dedicating to consider this rule. Thank you for your enormous commitment and attentiveness.
Thank you, Ms. Borchert. While Dr. Rasso gets set up, I would encourage everyone to take a mindfulness stretch. We are headed into a very technical testimony, and it may help your understanding. You ready?
I believe we're ready. How's my volume?
All right, Dr. Rasso, can you please share with us where you are employed?
I'm employed at the Climate Change Bureau of the New Mexico Environment Department.
And how long have you worked for NMED?
I've worked for the department for 7 years.
In those 7 years, what roles have you held with NMED?
I've worked for NMED as an air quality modeler and as a greenhouse gas emissions inventory specialist, and now as the Climate Change Bureau permitting section manager.
In your current role as the section manager, can you share what your job duties entail?
As the permitting section manager in the NMED Climate Change Bureau, I am responsible for overseeing the Bureau's technical and administrative implementation of approved rules, specifically the New Mexico New Motor Vehicle Emissions Standards and these proposed rules if approved by the board.
Can you share briefly your work experience prior to joining the department?
Prior to my time with the department, I was completing my PhD at Purdue University in analytical and atmospheric chemistry.
So I guess that covers your educational qualifications as well?
I also have a bachelor's degree in chemistry from Whitman College. Whitman, W-H-I-T-M-A-N.
Thank you, Dr. Rasso. Is NMED Exhibit 68 your resume?
Yes, it is.
Is NMED Exhibit 67 a written narrative of your testimony?
Yes, it is.
Was this exhibit refiled to correct a non-substantive fix?
Yes.
Do you have any other corrections that you'd like to make to your pre-filed testimony this afternoon?
I do. Equations throughout pages 5 through 8 of my testimony should say 10 to the 6th, not 1 to the 6th. The same equations on pages 5 through 8 use the carbon intensity of the standards from the proposed rule included in the petition rather than the revised versions included in the revised proposed new rule, which is NMED Exhibit 1. In addition, on page 18 of my testimony, I reference PNM qualifying to be regulated under the revised proposed new rule because of their issuance of energy transition bonds. This should say that PNM qualified to be regulated under PRC's carbon dioxide emission measurement regulation, which is 17.9.561 NMAC.
Thank you, Dr. Rasso. With those clarifying corrections, do you adopt NMED Exhibit 67 as your testimony today?
Yes,
Have you prepared a oral summary of that testimony?
I have.
And do you have a PowerPoint presentation to accompany your summary?
I do.
Okay, when you're settled, please go ahead and proceed.
Good afternoon. My oral summary of my testimony will focus on NMED's preparations to administer the CTFP, what participation in the program looks like for regulated parties, and how carbon intensities are modeled, including how Eastern Research Group has conducted life cycle analysis on behalf of the department. The NMED rulemaking team has carefully considered the scope and timing of these rules to balance reductions in greenhouse gas emissions, statutory requirements, and effective administration. We have considered our current and projected staff and contracting capacity and scoped the program's rules to prioritize the most critical components of a clean fuels program. We have and will continue to consult with other states' similar programs to draw on their experiences with staffing and rolling out this type of program. In designing our program, one key way we have eased our ability to administer the CTFP is by maintaining consistency with other programs wherever possible so we can rely on their experience and advice. We are coordinating closely with NMED's Office of Information Technology and our IT software development contractors to ensure robust development of a clean transportation fuel program data management system. As in other states' programs, the data management system will be used by regulated parties to register and manage accounts, register and manage fuel supply equipment, submit quarterly fuel reports, and generate credits and deficits quarterly, transfer credits to other registered parties, retire credits to satisfy deficits, submit annual compliance reports, and apply for and maintain alternative fuel pathways.
Dr. Razzo, you're speeding up.
Oh, am I too loud? Sorry. Thank you.
You're speeding.
Oh, too fast. We are in active development of this system and will launch each functional portion in advance of the appropriate program milestone in the proposed rules. I'd like to move now to what does this program look like for a typical participant. Section 501 of the revised proposed new rule requires that providers of regulated fuels register within 45 days of the effective date of the rule. Providers of opt-in fuel can register at any time. Registration is the first step of participating in the program, and once registration is complete, regulated parties will have access to the reporting and other functionality of the data management system. Providers of gaseous fuels and electricity, where the first fuel reporting entity is the owner of the fueling equipment, must also register their fuel supply equipment, or FSEs. Section 504 of the revised proposed new rule requires that fuel suppliers report fuel volumes quarterly. The report includes the information necessary for the appropriate credits and deficits to be calculated. Following the final submission of the quarterly report, the data management system will generate the appropriate credits and deficits and deposit them into the regulated party's account. Credits and deficits are calculated as shown in the equation here. Credits are generated when the value calculated is positive, and deficits are generated when the value is negative. The first part of this equation, which includes the volume of the fuel reported, the energy density of the fuel, and the energy economy ratio of the fuel vehicle combination, represents the amount of conventional fuel used or displaced. The second part of the equation is the difference in the carbon intensity between the appropriate standard and the EER adjusted carbon intensity of the fuel. It is all then converted from grams of carbon dioxide equivalent to metric tons of carbon dioxide equivalent. There are several types of credits that are generated outside of the data management system, including those for charging electric vehicles at home, which is referred to as residential charging throughout the rules. In this case, the electricity used as a transportation fuel isn't typically metered separately from other uses. NMED's proposal, like rules in other states' similar programs, obligates the department to calculate and issue credits for residential charging of EVs. We will do this following the same methodology as other states. Credits will be calculated for each vehicle either using vehicle telematic information submitted by a participating vehicle manufacturer or by calculating the amount of electricity dispensed for transportation using information on vehicle efficiency from fueleconomy.gov and the and information on average annual miles traveled by a vehicle from the U.S. Department of Transportation Federal Highway Administration. The department will then deposit the credits for each electric vehicle into the appropriate data management system account. Electric distribution utilities, automakers, and the backstop aggregator are eligible for these credits. It is important to note that while the proposed rule has a single EER value for light-duty electric vehicles in Table 8, it allows the department to determine vehicle-specific EERs when calculating credits for residential EV charging. As you can see in the equation for calculation of credits and deficits, the carbon intensity of transportation fuels is integral to the function of the CTFP. A transportation fuel's life cycle-based carbon intensity is the amount of greenhouse gas emissions released into the atmosphere per unit of energy summed across the fuel's entire lifespan. CTFP uses several types of carbon intensities. They can be roughly divided into the carbon intensity of the standards and the carbon intensities of individual fuels. The carbon intensity of the standard is the annual carbon intensity to which transportation fuels are compared to calculate credits and deficits. They're in tables 1, 2, and 3 of the proposed rules. Carbon intensities for fuels are associated with a fuel pathway code in the data management system. During quarterly reporting, regulated parties must specify the appropriate fuel pathway code for their fuel. There are several types of fuel pathways with associated carbon intensities. The types of fuel pathway that a volume of fuel may be reported under depends on the type of fuel. Section 201A of the proposed rule prescribes which type of pathways different fuels are eligible for. The types of fuel pathways for reporting is broadly the same as similar programs in other states. The types of fuel pathways each fuel type can use is also described in Figure 1 in my written testimony. Fossil fuels must be reported with the lookup table fuel pathways and associated carbon intensities listed in Table 4 of the proposed rules. Lookup table carbon intensities were calculated by Eastern Research Group for NMED. Alternative fuels other than electricity must apply for an alternative fuel pathway that is specific to the fuel production process and inputs. Alternative fuel pathway applications are divided into two types, Tier 1 and Tier 2. Tier 1 alternative fuel pathway applications are for fuels where the production process or feedstocks are well understood and a life cycle carbon intensity can be reasonably calculated using a simplified Excel-based calculator. Tier 2 alternative fuel pathway applications are for fuels where the production process or feedstock are more complicated and a full life cycle analysis modeling exercise must be conducted by the applicant. Applicant. Fuel producers preparing an alternative fuel pathway application or waiting for department review may still provide fuels in New Mexico. Such fuels are reported using the temporary table fuel pathways and associated carbon intensities in Table 5 of the proposed rules. Temporary table carbon intensities were calculated by Eastern Research Group for NMED. Electricity used as a transportation fuel is most often obtained from the grid through an electric distribution utility, or EDU. Electricity being reported as a transportation fuel that is on grid is reported using an EDU-specific fuel pathway. Pathways and carbon intensities calculated for an EDU service territory are used to generate credits both for the EDU and for other parties that provide electricity as a transportation fuel. Because of this, all EDU service territories in New Mexico must be assigned a carbon intensity in the program, regardless of whether the EDU opts into participating. Under the proposed rules, NMED will calculate and announce carbon intensities for EDUs in New Mexico annually. If NMED determines that it cannot reasonably calculate an EDU's carbon intensity, the rules allow NMED to substitute a statewide or regional carbon intensity for that EDU's service territory. Renewable electricity may also be reported as a transportation fuel either on or off, using either on or off-site generation. Renewable electricity is in the lookup table and has a carbon intensity of 0 defined in the proposed rule. Renewable energy certificates showing that the renewable electricity was generated in the same subregion as the electricity was used must be retired in a department-approved registry to report renewable electricity in the program. Finally, on-site non-renewable electricity that is being used as a transportation fuel must apply and be approved for an alternative fuel pathway to be reported in the program. Now I would like to return to fuel life cycle analysis and how the carbon intensities for the fuel pathways and the carbon intensities of the standard were determined. Every state that has adopted a clean fuels program has adopted a version of the Greenhouse Gases, Regulated Emissions, and Energy Use in Technologies, or GREET model, which was developed by Argonne National Laboratory. The GREET model is composed of parameters that are representative of how materials and our energy are used to produce fuel and deliver them for use. It is a complex model with numerous ways of changing inputs and assumptions. Individual versions of the GREET model are developed for specific use cases. This aims to guide system boundary selection and decision-making while conducting the modeling. Every state with a similar program has parameterized a GREET model to create a state-specific regulatory version that must be used for alternative fuel pathway applications. The US government has also developed specific regulatory versions of GREET for the Renewable Fuel Standard and various tax credits related to renewable fuels. NMED's proposal is no different, and the R&D version of the model is not intended for regulatory compliance. NMED contracted Eastern Research Group to parameterize a GREET model for CTFP and calculate standard fuel life cycle based carbon intensities for the carbon intensity standards in tables 1, 2, and 3 in the proposed rules. The lookup table, which is table 4 in the proposed rules, and the temporary table, which is table 5 in the proposed rules. Eastern Research Group began with R&D GREET 2023 for this parameterization. By doing this, NMED has moved closer to the research version of the model than Oregon and Washington, who began their parameterization with California GREET. The GREET model with New Mexico parameters, developed by Eastern Research Group, will be the Tier 2 calculator for CTFP and will be the basis for development of the Tier 1 calculators for alternative fuel pathway applications. In development of the New Mexico inputs for the GREET model, we have endeavored to make the required adjustments as simple as possible to facilitate regular updates to the Tier 1 and Tier 2 calculators. Argonne National Laboratory typically updates R&D GREET model annually, focusing on different areas each update. While Argonne National Laboratory's updates to the R&D GREET model are based on improved understanding of the scientific community about emissions at various stages of fuel life cycles, not every update will have a significant effects to fuel carbon intensities in New Mexico. The structure of Tier 1 and Tier 2 calculators is essential to program function and ease of alternative fuel pathway review. And fuel pathway review is necessary to ensure a level playing field. NMED will be monitoring R&D GREET model updates for their significance to the CTFP and providing updated Tier 1 and Tier 2 calculators as needed. Some of the parameters Eastern Research Group adjusted on NMED's behalf to New Mexico specific values include a preference for market allocation, adjustments of upstream oil and gas emission assumptions, and the handling of avoided emissions from animal waste, and indirect land use change values. Upstream emissions from the oil and gas production industry are heavily dependent on crude oil sources. Crude oil sources. The sources of crude oil that ultimately become transportation fuel in New Mexico are different from the other states with clean fuel programs. Most of the crude that ends up as fossil transportation fuel in New Mexico is extracted and processed in Petroleum Administration for Defense District 3, also known as PAD 3. PAD 3 includes New Mexico, Texas, and Louisiana. Eastern Research Group, on NMED's behalf, has included a detailed analysis suited to the crude oil sources for New Mexico's fossil transportation fuels that was generated using the Oil Production Greenhouse Gas Emissions Estimator Model, or OPGE, and that's spelled O-P-G-E-E. The PAD 3 OPGE modeling was based on a previous peer-reviewed analysis. NMED believes that this is the best representation of emissions associated with fossil transportation fuels used in New Mexico available. NMED also altered how avoided emissions from animal waste handling are accounted for in the temporary table pathways for the production of biomethane from animal waste. Several types of transportation fuel utilize material inputs that would otherwise have been waste. When the business as usual handling of that waste would have resulted in greenhouse gas emissions, it's common and appropriate for the life cycle analysis system boundaries to include the absence of those emissions. Every state with a similar clean fuels program allows this. The transportation fuels that most commonly account for avoided emissions in their life cycle analysis are biomethane, also known as renewable natural gas, which is produced from either anaerobic digestion of animal and other wastes or collected from landfills. Landfills that produce enough gas to be worth collecting are required to control gases produced from decomposition under air quality rules. Typically, this takes the form of flaring, which oxidizes methane to carbon dioxide. When a landfill captures gases and refines them to biomethane rather than flaring them, the life cycle analysis accounts for the avoided emissions as avoided carbon dioxide because the landfill is required to control the gases. Lagooning of animal waste leads to anaerobic digestion of lagooning of animal waste leads to anaerobic digestion of the waste and produces significant amounts of methane, which has a global warming potential of 28 times carbon dioxide. There are no federal or New Mexico regulations requiring that methane or other gases produced from animal waste handling be collected or mitigated. Because of this, life cycle analysis of biomethane produced from anaerobic digestion of animal waste accounts for the avoided emissions as avoided methane. In the California LCFS certified carbon intensities for biocompressed natural gas can be as low as negative 532 grams of carbon dioxide equivalent per megajoule. Selection of the correct system boundaries for modeling avoided emissions in this scenario is both difficult and complicated. Ideally, selection of what business as usual scenario is used in the modeling would account for both regulatory requirements and common practice. And it is much more common for agricultural operations to collect and utilize animal waste for other purposes than it was in 2009 when California first started its program and defined system boundaries for this type of life cycle analysis. Because of this, NMED has opted to model two scenarios for the temporary table fuel pathways for biomethane made from agricultural waste, both of which are different from those that other programs have used to conduct modeling for their temporary pathways. The first temporary fuel pathway assumes that methane emissions are not avoided from animal waste because of the CTFP, and results in a carbon intensity of positive 62.7 grams of carbon dioxide equivalent per megajoule. The second temporary fuel pathway includes accounting for avoided methane emissions, but rather than calculating the avoided emissions from the ground up using emissions factors, utilizes national estimates of the average methane emissions associated with manure based on the US EPA's National Greenhouse Gas Inventory. This results in a carbon intensity of negative 27.3 grams of carbon dioxide equivalent per megajoule, which is significantly higher than the values that other states have determined for their temporary tables. And by higher, I mean closer to zero. Although NMED used more conservative modeling assumptions than other states for the carbon intensities in this rule's temporary table, we may accept other modeling assumptions in alternative fuel pathway applications. We anticipate releasing further guidance in how we expect alternative fuel pathway applicants to select system boundaries for life cycle analysis of avoided emissions. But generally speaking, in review of alternative fuel pathway applications, NMED will consider what the best representation of reality is in the business as usual case. And that may mean including avoided methane emissions in some alternative fuel pathways. Finally, I would like to address how the department has decided to account for changes in how land is used due to the production of biofuels. The enabling statute for these rules defines the fuel life cycle to include significant indirect emissions from indirect land use change for CTFP. The department's proposed values are in Table 9 of the proposed rules. The values that NMED has proposed match the values used by California and Washington in their clean fuel programs. Oregon's clean fuel program used a different model to determine the indirect land use change value of corn ethanol. Yep. And the same model as other states for all other crop feedstocks. The values we have proposed were developed by the California Air Resources Board after a multi-year process with an expert working group, which included experts from industry, academia, nonprofits, and other interested parties. Researchers commonly find discrepancies in the changes in greenhouse gas emissions effects due to land use change from biofuel production. This is at least in part because estimating this type of value requires both complex modeling of global markets and attributing human behavior to multiple factors, of which biofuel production is only one. Because there is a general lack of consensus on the best estimates of the impacts of clean fuel standards on land use change, NMED has determined that the best path forward is to adopt the values that the California Air Resources Board adopted following the advice of its expert working group. The values that NMED has proposed are conservative but reasonable values for use in these rules. The California Air Resources Board has indicated that they will be revisiting the topic of indirect land use change and convening a new expert working group to examine if new values are needed, and if so, what values are the best estimations. NMED will be following the development of this expert working group closely and looks forward to participating in the process led by the California Air Resources Board. I would like to thank the board for taking time to consider this complex and innovative policy, and bear with me as I have to spell out words, and I'm happy to answer their questions.
Exactly 30 minutes, that was.
Thank you, Dr. Rasso. Two very quick questions for you. Will the project manager for ERG, John Kupal, testify on the next panel?
He will.
Is the purpose of your testimony to raise the New Mexico assumptions for GREET and explain the role of that model in the regulatory scheme rather than talk about the ins and outs of the model itself?
That's correct.
Thank you. Madam Hearing Officer, that concludes the testimony for our witnesses today. We do have one more witness on this panel that I explained earlier. I can fill the next few minutes with moving for admissions of exhibits, if that works.
Yes, please.
Oh. Okay, I got you. All right. For Mr. Vaughn, we have exhibit 34, 35, and the accompanying exhibits that are explained in his testimony, which are exhibits 36 through 62. I'd like to now move for admission of those exhibits into the record.
Right. Again, I won't read the entire list of 18 parties. Please indicate by raising your hand if you're in the room or speaking up if you're on the platform. If you have an objection to the admission of NMED 34, 35, or 36 through 62. I'll pause. Okay. Those exhibits are admitted.
Next, for Ms. Borchert, I'd like to move for admission into the record NMED Exhibit 63, 64, and the exhibits discussed in her testimony, which are NMED Exhibit 65 through 66.
Okay. Are there objections to NMED Exhibits 63, 64, 65, or 66? Please speak up. I'll pause. Okay, those exhibits are admitted.
And lastly, for Dr. Rasso, we have Exhibit 67, 68, and the exhibits mentioned in her testimony, which are NMED Exhibit 69 through 72. And I'd like to move for admission of those exhibits into the record.
All right. Are there objections to NMED Exhibits 67, 68, or 69 through 72? I'll pause. Okay, those exhibits are admitted. Thank you.
Thank you, Madam Hearing Officer.
All right. So we need to vacate each day by 5 p.m. This is one of the two occasions tonight and also the evening of November 17th when we're going to have an evening public comment session. It will be on the virtual platform only. We'll begin that at 6, and I'll invite comment until no one else speaks up, and then we'll end for the day. So I may or may not see you on the platform at 6. In any event, I'll see you here tomorrow morning at 9. Thank you all. Oh, yes. Go to a microphone, please.
One quick question. I understand there will be a fourth panelist for this panel, and I'm wondering if the department can confirm who that will be.
Good idea.
Thank you. The fourth panelist for this panel will be Colin Murphy.
Colin Murphy, thank you. All right. Anything else at all? All right. See you tomorrow.